think, and I didn't do this yesterday, but I think when we have witnesses testifying, I'm supposed to ask them if they're okay appearing on camera first. So what I'll do today is when I swear them in, I'll then ask them that, and if they're okay with that, then you guys can proceed, but if not, just keep the camera on something else, okay? Thank you. Are we ready to proceed? Okay.
Housekeeping matters.
Okay.
We are moving to admit the deposition of Detective Gary Stum with no objection from the Attorney General, and we're going to call that Move-ins Exhibit 46.
Okay.
And I have a copy for you here.
Okay, you can bring that up. Thanks. Thank you.
And Your Honor, yesterday we admitted Move-ins Exhibit 20, which was the TV guide that was used at the habeas proceeding. And there are some questions about, is it obvious where it's from and things like that. So we have offered a full copy of the newspaper from that day so that it's clear where it came from. And we're calling that Move-ins Exhibit 20A. And then because it's small and hard to see, we have a bigger copy of the more relevant pages specifically. We're calling that Move-ins 20B. And we would like to admit both. I understand the Attorney General does have an objection to those.
Yes, Judge, if you could just show them over the same objection that we post for the record as to Exhibit 20.
Okay. So just for the record, I note your objection. Go ahead.
Sorry, I assumed that before we consider them, but if you just show that, we'll just rely on the previously made objection.
Okay. So I'll note your objection for the record, but I'll admit them.
And I have copies of those as well.
Okay, thank you. It's been a while since I've looked at a TV guide, so.
I don't know if they even
Or anybody has. Thanks.
Oh, sorry, Your Honor. I gave you all of my
Oh, okay.
At this time, the Circuit Attorney calls Nicole Bailey.
Okay. Good morning. Come on up. Can you raise your right hand for me? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Okay. Do you have a problem appearing on camera? We have some media here. Okay. Thank you. So I'm just going to ask you to speak, get kind of close to the microphone and make sure your voice can be heard through it for everybody in the courtroom, and wait until the entire question is asked before answering. And if there's an objection, let me rule on that before answering, okay? Thank you very much.
Please introduce yourself.
I'm Nicole Bailey.
You might want to scoot your chair forward so you don't have to lean forward every time.
Miss Bailey, have you had any other last names?
Williams, Nicole Williams.
Where do you currently live?
St. Louis, Missouri.
Did you know Christopher Dunn?
Yes.
How did you know him?
We were childhood friends. We grew up together, one block over from each other.
Say that again.
We were one block over from each other. He lived on one block. I live a block over.
How old were you when you first met?
Maybe 6, 7.
What was your relationship like?
Good friends. We had a lot of friends, but we were all good friends in the neighborhood.
Did you communicate often?
Yes.
How would you communicate?
By telephone or when I would visit my mother, because my mother lived on Hebert. So, and I lived with my grandmother throughout the year, so summer, vacations, things like that, I was saying.
And where did your grandmother live?
In St. Louis County.
Let's talk about May of 1990. How old were you?
15,
And where were you living at the time?
St. Louis, Missouri.
How much time did you spend in the Wells Goodfellow neighborhood at that time?
A lot, all summers, anytime we were out of school.
And you and Christopher were friends at that time as well?
Yes.
Were you in high school?
In 1990, yes. I was in 9th grade.
In May of 1990, did you have a child?
Yes.
Boy or girl?
You say it again, I'm sorry.
Boy or girl?
A girl,
And what's her name?
Brittany,
What was Brittany's date of birth?
May 17, 1990.
What time was your daughter born on May 17, 1990?
About 7:40.
And where were you the night of May 17th,
In
1990?
Deaconess Hospital.
Do you know where Deaconess Hospital was?
It was right off of, what is that, near Clayton Road. It's not there anymore, but it's near Hampton. It was off of Hampton. I think it's SSM now.
Do you recall how long you were in the hospital before delivering your daughter?
I wasn't in the hospital before delivery.
Were you admitted the same day?
Yes.
How long were you in the hospital after giving birth to your daughter? if you
Maybe a
recall?
few days. I had a cesarean, so it was like maybe 2 or 3 days. I'm sorry.
Speak up a little more.
Okay.
Maybe get a little, pull the mic a little closer to you, I think. You have to be really close to it. It's
Okay.
just the way it is. Thank you.
Do you know who Rico Rogers is?
No,
At the time, did you know who Rico Rogers was?
no.
Do you know who he is now?
I just know he's the person that was named in the case, but I never met him. I didn't know him then.
Have you heard that Rico Rogers was murdered on May 18th, 1990?
Yes.
How did you become aware of that?
I found that out, I think, when I called Nell, and she told me that had happened, but I didn't know the name of the person. I just knew what had happened.
And when you say Nell, who are you referring to?
Martha Dunn.
Do you know how Arnetta Dunn is related to Christopher Dunn?
Is his baby sister.
Were you in the hospital when Rico Rogers was killed?
Yes.
The day before, on May 17th, 1990, what were you doing after your daughter was born?
Say it. Can you repeat that question again?
The day before May 18th, 1990, on May 17th, 1990, what were you doing after your daughter was born?
Laying in the hospital, watching TV, talking to family, friends, calling everybody, called Chris, called everybody.
So you spoke to Chris that night.
Yes. We
What did-
talked all the time.
What did you speak about?
Me having a baby.
During the several days of your stay in the hospital, how often did nursing staff come in to check on you?
All the time, because I had a cesarean, like I said, so they had to come in, check the scar, check me, you know. I was young too, so they came in a lot.
On the night of May 18th, 1990, Did you talk to Christopher Dunn that night as well?
Yes.
Do you recall approximately what time you spoke to Christopher that night?
It was late. I remember us watching TV, watching Hunter, and me telling him about Hunter on TV.
Do you recall what channel you were watching Hunter on?
I'm not sure. It wasn't a cable channel, but I'm not sure exactly what channel. It may have been 11. It had
You
to be one of
say-
the basic channels.
You say it wasn't a cable channel. Why do you think that?
We didn't have cable in the rooms in 1990.
I am going to show you Exhibit 20, which has been previously admitted. You can turn to it in your binder there, tab 20, and it will also be shown on the TV up here. Have you seen this document before?
Yes, I have.
Can you tell me what it is?
It's a copy of a TV guide from May 1990.
And I have a better copy that I'm going to hand you now, which is Exhibit 20B. Can we go to the first page of 20B, please? And can you zoom in on the date at the top? Do you see the date of the document?
May 18, 1990.
And what is this document?
St. Louis Postage badge.
On the second page, still hard to see, but we'll zoom in on the TV. Does this appear to be the same TV guide as Movement 20?
Yes. Yes, it is. It's the same.
Do you see channel 11?
Yes.
And do you see the TV show Hunter?
Yes.
What time does it say that Hunter was playing that night?
11 p.m.
Is that consistent with what you recall?
Yes.
Is it consistent with when you remember speaking to Christopher Dunn?
Yes.
When you spoke to Christopher Dunn that night, what was his demeanor like?
He was fine. He was talking, laughing about me having a baby at 15. Just how we always talk for hours on the phone,
So you spoke for a long time?
all the time.
How long do you think you spoke?
I don't know. So the nurse came in and said, I want to take your vitals, and so that was after Hunter.
Was Christopher's demeanor different when he spoke with you on May 18th than when he spoke with you on May 17th?
No, not at all.
When did you get off the phone that night?
It was after Hunter, so it was late. I don't know exactly what time.
Do you recall why your conversation ended?
My nurse came in, said she needed me to take vitals. The nurse came in and said that she wanted me to take my vitals.
I'm now going to show you what has been marked as Exhibit 19, which has also been previously admitted. You can turn to tab 19 of the binder, and again, it'll be on the TV screen as well. On the first page of the document, do you see a title of the document?
Yes, it just says affidavit.
And in the third paragraph down, do you see where it says, I am the custodian of the records?
Yes.
Where does this document say the records are from?
St. Alexis Hospital.
And then turning to page 5. In the top left, do you see a hospital name?
I think I'm looking at the wrong page here. Yes, Deaconess Hospital.
Yes. Do you know what the relationship between Deaconess Hospital and St. Alexius Hospital was?
No.
On page 18, in the top left, do you see that it says Deaconess Hospital again?
Yes.
Is that where you were when Christopher Dunn, strike that. Is that where you were when you had your daughter?
Yes.
Underneath where it says Deaconess Hospital, do you see what this document is called?
Can't see it. Nurse's note. The nurse's notes.
Looking at the chart, what is the first date that you see?
I can't see that. 5/18/90.
Do you see the time that was notated by the nurse?
I can't make it out without my glasses. I think what
It's a
is
little hard to read. On the following,
it? Looks like 2:30.
maybe, and going down to the second time, do you see the date there?
Yes, 5/19/90.
And what time is there?
0100.
So 1 a.m. on May 19th, 1990.
Mm-hmm.
Reading that first short sentence, what does the note say that the nurse notated?
Vital stable. Denies pain, discomfort.
Is 1 a.m. consistent with when you remember the phone call with Chris ending?
Yes, about that. It was late.
Do you know where Chris was speaking to you from?
From home,
How do you know that?
because I had talked to Neil there.
Who called who?
I don't remember, but I think I called him.
Do you know if Chris had a cell phone?
No, absolutely not.
Do you know who else lived in the home that you called?
His mother, his sister Dee Dee. I think Angela lived there too. And Neil.
I need you to keep your voice up. I'm having trouble actually understanding you.
It was his mother and 3 sisters.
After your call with Christopher ended, what happened?
After it ended, I think I called him back or something, and I talked to Neil, and they said he was being arrested.
Did you try to come forward and tell someone that you were speaking with Christopher Dunn on the night of May 18th, 1990?
Yes.
Did you ever testify previously on behalf of Christopher Dunn?
No.
Do you recall testifying in proceedings after he was tried?
Yes.
When was that?
I think it was in Licking, maybe, it's been a while, 5-6 years ago.
Did you ever sign an affidavit regarding this matter and what happened on May 18th, 1990?
Yes.
Ms. Bailey, I'm now going to show you Exhibit 13, which has also been previously admitted. Do you recognize this document?
Yes, I do.
Is this the affidavit that you signed?
Yes.
Do you see in the 6th paragraph down where it starts, I directly recall?
Can we blow it up? I can't read it. Okay.
And can you read that first sentence?
I distinctly recall that Friday night, May 18, 1990, the night after my daughter Brittany was born. Chris called me late night just to talk.
Did Chris call you that night, or did you call him?
I'm having trouble remembering that because we call each other all the time, like all day in a day. So he may have called me. I thought I called him, but
Did you have a cell phone at that time?
no.
Did he have the phone number for your hospital room?
I'm not sure.
Did you testify at Christopher's original trial in 1991?
No.
Why not?
I mean, I tried. I was contacted by somebody, but that was way after. But I guess nobody wanted to hear what I had to say.
And how old were you at the time in 1991?
15. I may have been 16 then. I would be 16, 1991.
How old was your daughter at the time?
If it was May of 91, she was a year old.
On May 18th, 1990, when you were on the phone with Chris, were you on any medications?
No.
From 11 p.m. on May 18th, 1990 to 1 a.m. on May 19th, 1990, were you on any medications that could have affected your mental clarity?
No. I was fine after I had my daughter.
And last question, Nicole, why are you testifying today?
Because this has been a nightmare for all of us, you know, more for Chris. You know, but I was a child, and I tried to tell them then that he couldn't have been there. I was on the phone with him. And I mean, anybody that knows us at that time, we talked on the phone for hours all the time. I would have known if Chris was upset. I would have known if something was going on. We was on the phone, and all of a sudden, boom, I have a baby, lose a good friend. And it was just like that. And here, I'm almost 50 now. I was 15 then. My daughter's 34 years old. I remember her birthday because I remember when he was basically just taken out of our life.
Thank you for testifying today. I have no further questions at this time.
Thank you.
Thank you, Ms. Huson. Ms. Eastep or Mr. Crane, do you have questions?
Good morning, Ms. Bailey.
Good morning.
You testified that on May 18th of 1990, you were 15 years old, is that right?
Yes.
And at that time, you would have been about 24 hours post-op from a C-section?
Yes.
And that was, is it my understanding that was a scheduled C-section, not an emergency one?
It was scheduled.
It was scheduled, okay. And on May 18th, you were in fact on several medications, isn't that right?
Not any medications. That I was awoke the whole time I had my daughter. I was not sedated.
Okay, but you just testified that you were on no medications. Did I hear that testimony correctly?
Yes.
Okay.
That would have impaired me mentally. I was.
Well,
I'm sorry.
did you just testify that you were on no medications, you were not medicated?
Yes.
Well, let me ask you, did you just testify that you were not on any medications?
That would impair me mentally.
I believe the question was, were you on medications that would impair you?
I think that was the follow-up question.
Okay.
So the first question was, were you on any medications?
Okay. Sustain.
You said that you testified under oath previously in this matter. Is that correct?
Yes.
All right. And whenever you testified at that time, you were under oath?
Yes.
And you swore to tell the truth?
Yes.
All right. May I approach, Judge?
You may.
I'm going to show you a portion of that transcript. And you don't have it in front of you, so I'll come show it to you. And you just let me know if I read it correctly.
Mm-hmm.
And this is page 64. And I'm going to start. I know you said you didn't have your glasses. I'll read it out loud, but I'll have you read along with me, okay? So you're asked on line 4 question, and you'd had several blood transfusions. No, I only had one blood transfusion. Question, one blood transfusion. Do you remember being on medication? Answer, I wasn't on any medication. Question, you weren't on any medication? Answer, Question, no, nothing for the pain or anything like that after having a baby? Answer, no. Did I read that correctly? And so all I'm trying to establish, Ms. Bailey, is that you were on some medication, correct? I
Not
understand it's your
anything that would-
testimony that it was not impairing your,
Compound question. She would rather answer the question.
well, I didn't finish asking it yet.
Go ahead with your question.
Thank you, Judge.
Re-ask the question.
I understand that you testified that you weren't on any medication that you are saying impaired your ability to remember, but my question was, were you on any medication? Okay, and so,
No, I was listening to what she said and just said, as if I understood her question.
okay, so you understood that question?
Yes, I understand your
Okay.
question.
And so, in fact, on May 18th, you were on several medications, including some pain medications.
That I refused when it was offered.
Okay,
I
so
wasn't
if,
in any pain. Yes, I was offered medications.
okay, so if the medical records indicate that you were given those medications, those would be false?
I wouldn't remember that.
Okay, and so if the medical records indicate that you were on, let's see, Parladel, Mylicon, Dialos, Percocet, Phenergen, Visceral, and Demerol, all given to you at least twice on May 18th as indicated in Move-ins Exhibit 19.
That would not be correct.
That would not be correct?
That would not be
Okay.
correct. Because I wasn't in any pain. I was walking around doing everything.
All right.
No.
And one of the
Just wait
reasons
for
you
another
could,
question.
one of the reasons you could not be on any pain is because you were receiving pain medication. Isn't that true?
Can you repeat that question again?
One of,
There's I'll sustain that objection.
you also were in need of a blood transfusion at some point, correct?
Yes.
And you did not receive that blood transfusion until 2 nights after, or I guess 3 nights after your C-section. Is that correct?
Yes.
And I know you had been asked previously, at previous hearings, we just saw a part of it, if you were given 1 or 2 blood transfusions. Do you recall that?
No, I don't.
You don't recall the transfusions or
Yes,
being,
yes, I got the transfusion. I don't recall exactly the dates.
being
It's after
asked
30
about it?
years. Right.
Okay. And I'm not a medical professional, Miss Bailey, but you're the one who received.
Just proceed with your question, Ms. Stum.
You tell me if you know, but if your medical records indicate you received 2 separate transfusionists and 2 separate transfusions, is that considered 1 transfusion to you or 2?
That would be 2.
Okay. So if your records indicate that you received 2 transfusions, would that be accurate?
I don't know what my medical, what transfusions I had.
Okay.
Where we going with this?
So you don't recall today if you had 1 or 2?
I know I had 1 transfusion. I don't know if they gave me 2 at the time, but it was 1 transfusion that I remember.
Okay. And you also had been suffering from a headache since receiving your epidural, is that right?
Yes, I did have a headache after.
Okay. And in fact, you complained of suffering of that headache for multiple days after giving birth or having your C-section. Is that right?
I don't remember if it was days, but I did have a headache after having a baby.
Okay. And if the medical records indicate you were still complaining of that headache 3 days later, would that be accurate?
If that's what they wrote down, maybe, but I don't remember having a headache for 3 days. But I did have a headache after I had my daughter.
All right. And you were aware that your friend Christopher Dunn was facing murder charges in 1990. You became aware of that at some point. Is that fair?
Yes.
Maybe not the night that you testified that you spoke to him, but at some point.
Yes.
All right. And I know that you said you tried to talk to the police, but that was not, or you tried to talk to someone, but that was not until after his trial. Is that right?
Can you repeat that?
I will. The court reporter wants me to repeat it as well. You testified that you tried to talk to someone, but that was not until after he had been to trial.
Yes, I was 15 years old. I didn't know who to talk to.
Okay. And the first person that you were contacted by was an attorney sometime later.
Yes, Emily Blood.
Okay. And Emily Blood, oh, all right. So would that have been, and you may not know, but would that have been during his post-conviction relief time?
I don't know.
And you spoke to Emily Blood. So she was an attorney representing Christopher Dunn.
I don't know if she was an attorney, but that's who I talked to.
All right. And that would have been after he was convicted of murder.
Yes.
And I believe that you came down to the city and talked to Emily Blood. Is that fair?
Yes.
Do you recall where you talked to her? Was it at a courthouse like this or somewhere else?
No, it was at a courthouse,
All right. Was it in a courtroom or like out in a hallway?
out in the hallway.
And in fact, you talked to her for quite a long time.
Not a long time. She basically just greeted me, and I told her I was there. My grandmother brought me down.
Did you talk to her about what you've testified to today?
I just told her what I'd already told her before. That's why she told me to come down, but I didn't testify or anything.
Okay. So you talked to her in a courthouse. You had talked to her sometime previously?
Just to come down. She invited me down here.
Okay. And you told her, what you told her was all about that night, what you remembered from May 18th?
I don't remember her discussing that with me at all at that time when we got to the courthouse.
All right. Just give me 1 second, Miss Bailey. Can I approach, Judge?
You may.
All right, I'm going to show you another portion of your sworn testimony from the habeas hearing in 2018, okay? I'm going to start on page 67, line 5. And I'll have you look along with me because it gets a little choppy at one point. So question, now if you knew you talked to Chris Dunn and you knew about the shooting, and you say, why didn't you come forward at trial? Answer, actually, question, I mean, you knew about this, right? Answer, actually, I did. Actually, Emily Blood contacted me. I came down to the city. I told her everything about everything I'm telling you today. I did what I could. I was 15 years old. Did I read that correctly?
Yes, she read it correctly.
And so you told Emily Blood everything that you could remember about that night. Did that refresh your recollection?
Yes, I did. She knew about that. That's why she had me come down.
Okay. And you knew that that was important to tell her everything you've testified to, both at the habeas hearing and today?
Yes.
All right. And so your testimony today, Miss Bailey, is that you were speaking to Mr. Dunn on the phone around 11 to 1 a.m., roughly,
Yes.
give or take? That you don't know precisely.
No, I don't. But it was late. We always talked on the phone for hours.
Sure, so around that window.
Yes.
Maybe your memory maybe is off a couple minutes on either scale, but we're talking about that chunk of time frame.
Yes.
And your memory or your testimony is that you would have been talking to him on his home phone.
Yes.
And I understand from your direct examination that maybe it's unclear who called who, but at least you knew he was home because you also spoke to his sister.
Yes.
And I understood that testimony correctly?
Yes.
Okay. So would you, and you said he did not have a cell phone.
No.
So you would agree with me, Miss Bailey, that if Christopher Dunn was driving around the city from 10 a.m. to midnight, he could not have been at home speaking with you on the phone.
Right.
And if Christopher Dunn was at a girl named Terry's apartment at midnight forward, he could not have been at home talking to you on the phone.
Repeat the question.
If he was at an individual named Terry's house, then he couldn't have been speaking.
This is not an expert witness, and she's asking hypotheticals about
Judge, I think she has personal knowledge as to where she spoke to Mr. Dunn, so she can answer these questions if she has knowledge.
I'm going to overrule the objection.
And so if Christopher Dunn was at someone named Terry's apartment and not at home, he couldn't have been speaking to you on his home phone. Would you agree with that?
We were on his home phone talking. I don't know about Terry or
Okay.
whoever you're talking about.
And then if Christopher Dunn left his home at 11 p.m. on the 18th and didn't come home until 2 a.m. the next morning, he couldn't have been on his home phone speaking to you. Is that fair?
He was on his home phone
Hang
speaking.
on, hang
to
on.
me.
What's that?
This is speculation.
I don't see it that way, so I'm going to overrule the objection.
You can answer the question.
Can you repeat the question?
Sure. If Christopher Dunn had left his home at 11 p.m. on the 18th and didn't return until 2 a.m. on the 19th, so 3 hours later, he couldn't have been talking to you on his home phone during that time.
I'm not really understanding the question, actually. I
Okay.
know I talked to Chris for hours at 11 o'clock.
Let me
I don't-
repeat the question and make sure you understand it, okay?
Yes,
So your testimony is that you spoke to Chris on his home phone.
yes,
And my question, and you said that it had to have been at his home
Yes.
because of the landline.
right.
So my question to you is, based on your knowledge of him having a cell phone or the number that you called him on, if he was not in his home from 11 p.m. until 2 a.m., there's no way that you could have been speaking to him on his home phone.
I still don't.
Yeah, I think you need to clarify your question.
I'm going to walk it. I don't think she's answered this one.
I'm going to overrule that. I'm going to overrule that objection.
I'm going to walk it back. I just want to make sure that we understand each other. He overruled the objection.
I did overrule the objection.
Okay, Ms. Bailey, I'm not trying to ask you a trick question. It's
It
just,
seems,
if you spoke to Chris, your testimony is that you spoke to Chris Dunn on his home phone.
absolutely.
Okay, my question to you is if Chris Dunn was not at home from 11 p.m. until 2 a.m.,
I don't know if he wasn't at home. He was at home when I talked to him.
so you would not have been able to talk to him on his home phone if he wasn't home?
No.
Okay, thank you. No further questions.
Okay. Do you have further questions, Ms. Huson?
Ms. Bailey, I'm going to take you to Exhibit 19 on page 13. Do you see the title of this document?
Deaconess Hospital medication profile.
And at the first part of this chart, do you see the date listed on the left?
518.
And I'm sure I'll pronounce these wrong, but is that next to a medication?
Yes.
What is that medication?
I have no idea what that is.
Halcyon?
Halcyon, 25 milligrams.
And then do you see where it says Heplock?
Yes.
What date is next to Heplock?
518.
And the medication below that, what date is there?
520.
The medications between Halcyon and Heplock, what dates were they shown on the chart?
518 and then 520.
For the medications on May 18th, on the chart on the sixth column, do you see a date?
On the chart, 6th column. 518.
And do you see times on certain medications on the chart underneath that column?
I don't see anything right there. Which one are we looking at? Okay. I see 1018 on 518.
For the 10 and 18, let's say 10 and 6, do you see any other times on Parladel after 18 that you were given that medication on May 18th?
No.
What about Fiazol?
No.
Milacon is a little hard to read. Can you see what time it says you were given the Milacon?
I can't read it from here.
Are you aware that Milacon is a gas medicine?
No, I didn't. I was 15.
And the Dialos, do you see what times you were given that one?
Looks like 1018.
And can you read when you were given Heplock?
I can't read it from here. I see a 2 and a 5. I can't make it out.
So you see 215.
Yeah, I see a 2 and I see a 5.
Do you know that Heplock is an anticoagulant?
Now, exactly what is that?
Judge, can
I
we take
don't know.
judicial notice of some of the medications on this list? I have page vaults from WebMD with what these, what Heplock and Milacon are. Milacon being the gas medicine and Heplock being an anticoagulant.
Is there any objection to that?
No, Judge, I would just ask that we do it for all of the medications.
Okay,
We can go on the internet and do that, or
Okay.
take judicial notice of what all the medications are, which is fine as well.
okay.
So after 6 o'clock that night, the medications that you were given were only Milacon and Heplock, according to this part of the chart.
Okay.
Scrolling down to the bottom of the chart, actually, can we go to the full page? Looking at the 518 column again, for the medications at the bottom of the chart. Can we zoom in on the bottom of the chart now? Thank you. For the first medication, do you see times that you were given that medication on May 18th?
I can't see the times. I see something written there. I don't have my glasses.
It's hard to read. Do you see the Phenergan medication? And what time you were given that one?
I cannot see that. I see JS. I see 1310 something.
1310, so
Mhm.
1:10 p.m.
Okay.
Do you see, sorry. Do you see the Vistaril medication
Yes.
and what times that one was given?
It looks like 0230.
And was there another time for that one?
There's a 630. I can 0630 630.
And then for the last medication on this chart,
Okay.
for the Demerol, do you see what times you were given that one as well?
Oh Lord. 0230.
And do you see another time for that one as well?
I can't make that out. That's
Can we zoom on that one a little bit?
Is that you, Miss Bailey? Okay, that's okay.
okay. That's a little better. Looks like 0230, and it looks like a 06, and I can't make out the other numbers.
So, we can't read what is after the 6, maybe. After 7 o'clock on May 18th, you were only on Mylicon and Heplock.
According to the chart.
And then let's look a little bit at May 19th. For the Parladel, do you see the first time that's written down?
I see it, but I can't make out what it says. 0818, I think.
Can we zoom in a little bit? What about the Fiazol?
It is 0818, looks like.
08 and 18. And then the Mylicon, do you see the first time that's given?
Looks like 0813.
08 and then 13.
I don't know.
And then the Dialos?
08, I don't know what the other two numbers is.
We'll do this again for the Heplock.
I see a 606.
And then at the bottom of the chart, the last few.
Miss Bailey, would it help you to get closer to the chart? If you walked over there, could you see better?
I don't know, it looks kind of jumbled to me, but maybe.
Okay. Well, if it would, you can feel free to do that, okay?
Okay, looks like 818.
So for the Percocet, what's the first time that you see there?
818. 08.
And then do you see any times for the other medications on
No.
this chart? What times did you talk to Chris roughly between May 18th and the morning of May 19th, 1990?
It was late that night, like I said. Hunter came on, I guess, about 11. Me and Chris was known to talk on the phone sometimes a day late. So it's only because the nurse said get off the phone so I can do the vitals. So it was way late.
Do you recall any of the medications you were on affecting your memory in this case?
No, I was telling him about the baby, about Hunter, just regular conversation.
No further questions. Thank you.
Thank you, Ms. Huson. Ms. Eastep, do you have further questions?
Nothing further questions.
Okay, thank you for your testimony. Ms. Bailey, you can step down. We can? Sure. We'll take a 5-minute break here.
He was still there?
Right.
And Judge, at this time, will now read the testimony of Martha Dunn.
Okay.
And that begins on the Bates ending in 413. Would you state your name for the record, please?
Martha Jean Dunn,
And what is your relationship to move-in Christopher Dunn?
mother.
And where were you on May 18th around midnight and in the early morning hours of May 19th, 1990?
At home.
You were at home, and what were you doing?
We was watching TV.
Do you remember what you were watching on TV?
I remember the name of the picture. I don't remember what it was about.
Okay, what was it?
Hunter.
Who else was there with you?
3 daughters, Christopher, Wilford, and Terrence Long.
Okay, and what was Christopher doing? Was he still watching TV?
He was watching TV at first, and then he was talking to a friend of his, Nikki,
And how do you know that?
because Nikki had a baby the day before.
And how do you know that it was Nikki he was talking to?
He said it was Nikki. He said, Nikki, a mama. Nikki just had a baby.
About what time was that when that phone conversation took place?
About 12:30,
And how long was he on the phone?
maybe 30 minutes.
So he started talking to her around midnight?
Uh-huh.
And before that, what was he doing? Sorry,
Watching-
before that, what was he doing then?
Watching TV.
Watching TV. That's it for the designations.
Okay, thank you.
Your Honor, at this time, the circuit attorney would call Dr. Nancy Franklin.
Okay. I'll let you put your stuff down first. Can you, wait a second, I got it. Do you solemnly swear that the following testimony, or that your testimony, why am I forgetting? Hang on, let me do it. I was thrown off by the camera. First of all, do you mind being on camera? I'm okay. Okay. Thank you for asking. Okay. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you. We got through it. And just make sure you're close to the microphone and keep your voice up, and wait until the entire question is asked before answering, and if there's an objection, let me rule on it before answering, okay?
Okay.
Thank you. You may proceed.
Please tell us your name.
Excuse me, my name is Nancy Franklin.
Tell us a little bit about yourself, Dr. Franklin.
I'm an eyewitness identification expert. I have a PhD in psychology. I'm a cognitive scientist. Bachelor's degree from University of California at Santa Barbara, PhD, both of these in psychology from Stanford University in California. I was a faculty member at Stony Brook University in New York for 30 years and retired in 2019. I've been serving as an eyewitness identification expert since 2007.
In your time as a professor, what kind of classes did you teach?
Well, there's the undergraduate courses and also master's level and PhD courses. I largely taught the big service courses for undergraduates, introductory psychology, the survey course in cognition and perception, again, my broad field, and then an upper division course in human memory, which is my specific area of expertise, psychology and law, some seminars. I directed the honors program, and also taught courses at the master's level and PhD level, largely in cognition and memory.
And as part of your academic career, did you publish any articles?
Yeah, that's the primary obligation in the kind of university where I was. So I directed a lab. I was a principal investigator. I had PhD students who I trained. We conducted research the full time that I was at Stony Brook, and actually I was doing it as a PhD student and an undergraduate as well. And we would publish our findings, attend conferences, present at conferences.
What are some publications that you've written that specifically relate to memory and eyewitness identification?
For example, we've done and published research on what's called the weapon focus effect, which is a phenomenon whereby the presence of a weapon in a situation draws attention toward itself and away from the person who's holding the weapon. We've published research on the impact of various kinds of emotion on eyewitness reliability. I'll stop there.
And also as part of your academic career, what talks or colloquia have you done related to eyewitness identifications?
Well, talks all the way through my career, and again, my training as a student at various academic conferences. So, usually a couple of those a year. Since I began serving as an eyewitness identification expert, I've given several continuing legal education trainings for attorneys, for judges, and also for the public.
Talk to us a little bit more about the legal CLEs that you've given specifically to judges and lawyers.
Sure, and also prosecutor's office. I've been invited most commonly by public defender offices to present, lectures on various factors related to eyewitness memory that can impact the accuracy of someone's testimony. So largely it's been public defender offices, and also several universities have asked me to speak to their law students. I was invited by the Louisiana Black Judges Association to come address them. I was invited by a prosecutor's office also in Louisiana to address them. I gave a keynote address at the National Association for Criminal Defense Lawyers several years ago. I've given several trainings for the New England Innocence Project, and in a few weeks I'm doing a judicial training specifically on police identifications from surveillance images.
Dr. Franklin, what professional organizations do you belong to?
I belong to the large, sort of all-encompassing organization of cognitive scientists. That's called the Psychonomic Society, Psychonomic. And then there are a couple of organizations that are specific to this area of expertise involving eyewitness memory, and those are the American Psychology Law Society and the Society for Applied Research in Memory and Cognition.
Can you explain a little more why those specific organizations are more important to your line of work?
Yeah, it's just, how many talks are particularly relevant to the kinds of issues that I normally engage in. So at the Psychonomic Society meeting, people are reporting certainly on memory research, memory errors, eyewitness errors, that's certainly there, but there's a large number of sessions on language understanding, decision-making, visual perception, auditory perception, animal cognition. It's just a broader range, and so it's most exciting for me to attend the conferences where every session would be important for my professional activities.
Dr. Franklin, how many times have you served as an eyewitness identification expert?
Somewhere between 85 and 90 at this point.
And how many of those have you testified in?
Actually, that is the number where I've testified. I've consulted in many hundreds.
Dr. Franklin, you were retained in this case by the Midwest Innocence Project, correct?
Yes.
What were you asked to do by the Midwest Innocence Project?
I was asked to review a body of discovery, and that included police reports, photos both of the crime scene and of the identification procedures, trial testimony, affidavits, transcriptions of interviews, memos, and notes regarding interviews, the Rule 91 hearing transcript. I think I've probably hit all of what I reviewed and relied upon. And then to report my opinion about the reliability of the identifications of Mr. Dunn by the two young men who identified him, Mr. Stepp and Mr. Davis.
Are you charging any fee for your work in this case?
No.
You're doing this pro bono?
Yes.
Did you create an expert report detailing the eyewitness identification opinions you reached in this case?
I did, yes.
Were the methods and research you used to create your report typically used by eyewitness identification experts in your field?
Yes.
We went through the documents that you reviewed when you looked at this case. Were these documents that you relied on the type of documents that are typically relied on by experts in your field?
Yes.
Your Honor, I would move to certify Dr. Franklin as an expert in eyewitness identification.
Any objection? No, Your Honor. Okay, she will be so certified.
Dr. Franklin, what opinions did you form after reviewing the record in this case?
Broadly, my opinion is that the identifications made of Mr. Dunn were highly unreliable, and that they were likely the result of some, any or all of inference, post-event suggestion, and possibly coercive influence or pressure and incentives.
Dr. Franklin, if you turn to tab 33 in that very large binder in front of you, and also showing on the screen is Move-ins Exhibit 33. Do you recognize this document?
Yes.
What is it?
This is the revised version of the report that I provided to you, I think, last month, fairly recently.
And if you want to go through it, is it a fair and accurate copy of your report in this case?
It looks to be, yes.
Your Honor, I would move to admit Move-ins 33.
Any objection? It will be admitted.
Dr. Franklin, I want to talk about your first opinion about how the identifications of Mr. Dunn by Michael Davis and DeMaurice Stepp were highly unreliable. First, how does identification research in a laboratory affect the ability to apply it to actual crimes?
We conduct this scholarly domain as a science, the same way medicine and physics study the phenomena in their fields. You have to have controlled experimental circumstances where you know what the factors are that are under investigation at the time. So you've got various conditions that you're comparing with each other. Importantly, ground truth. You know who the perpetrator is because you've set up this situation. And like these other scientific fields, properly conducted experiments allow you to draw scientifically responsible conclusions about how and whether a factor influences an outcome.
Is there any research that compares the results from these laboratory experiments to actual crimes?
There's some, where actual criminal situations allow interpretation of data. So there's, I guess, two branches here that come to mind. One is looking at contributing factors to exoneration cases, DNA exoneration cases, where we now know that the person who was convicted was innocent. And for example, we know that somewhere between 2/3 and 3/4 of those had involved misidentification. That research is very valuable in understanding how wrongful convictions and misidentifications in particular can occur. The second prong is examining where we can how real-world circumstances impact reliable eyewitness reports. And to the extent that we can do that, we find hearteningly that the patterns of factor influence reflect or parallel what we see in the lab. What we find consistently is that the lab tends to underpredict how impairing these phenomena are. For example, because in the lab, it's hard to make people fear for their lives. And so, many of these factors are sort of dampened down compared to what we see in the real world.
Dr. Franklin, I want to start with the optimal conditions of an eyewitness identification. What are the results in laboratory research under optimal conditions of eyewitness identifications?
Well, the optimal conditions don't even involve memory, right? So, we're looking to see how well people can process faces and make even perceptual matching tasks. So the most optimal circumstances would be having a face at the top of the screen and then having a photo array below that face while it stays on the screen and telling people, here are 10 faces below that top face. Is that person at the top in this set? If he is, it's another picture taken the same day. So again, optimized. There's not going to be a big appearance difference. And if he's not there, then that should be what you tell us. So under these circumstances, the images that are used are full face, good lighting, close-up view, for as long as the person doing the task wants to look. And again, they can go back and forth and make all the comparisons they want because there's, that face is still at the top of the screen. And what we find, remarkably, is that people make, in the condition where the right answer is he's not there, people make about 1/3 misidentifications. They pick someone, and if you pick someone in that situation, you're making a misidentification. So what we learn from these studies is that people have a tendency to perceive a match even when it's not there, to perceive that they're recognizing someone when they're not.
What factors can increase the risk of misidentification?
Anything that draws down from those optimal circumstances. So if the perceptual conditions are worse in terms of only a glimpse at the face, and then the face isn't there anymore, and now you're on your own looking at these photos, who knows when later. If the lighting is low, if there's distance involved, if any parts of the face are covered, or if your own, as the observer, if your own internal circumstances are distracting. If you're under stress, for example, then your cognitive processing won't be fully on the task at hand. You will be, for example, looking for escape routes or how to protect yourself. If there's a weapon in the situation, as I mentioned before when you were qualifying me, weapons tend to draw attention away, which means you're not processing the face as well or as much as you would have if you hadn't been distracted by the weapon.
Dr. Franklin, explain how familiarity with a perpetrator can affect identifications.
Well, the first thing to say is that familiarity is a continuum. So you can go all the way from never saw the face before to your mother. And what we know is all the way at the extreme where your mother is on that spectrum, people tend to be quite good at recognizing someone they are truly familiar with. But that criterion for what it takes to be truly familiar, that's a high bar for people in my field. In that middle range, people can have some level of prior exposure to or some level of acquaintance with someone, and if it's a casual acquaintance, if they've seen them only a couple of times sort of around, particularly if they've never interacted with them directly, then the performance in being able to identify that person falls much closer to the truly unfamiliar, stranger end of the spectrum, where people are making 1/3 misidentifications, even in that perceptual matching task.
Dr. Franklin, how can an eyewitness misidentify a stranger perpetrator as someone that is familiar to them?
Well, again, people have a tendency to try to find a match, or to perceive familiar face, or perceive that they're recognizing the person more often than they actually are seeing someone who's familiar. And let me, if it helps, I can give you a published, finding on this.
Please do.
Okay, so this is a finding by Kerstholt, Kerstholt, and colleagues, from, I believe, 1992. So everybody who participated as a as a research subject was actually on staff at a perceptual research institute. So these people are much more familiar with the foibles of perception than the average person. This institute had, I think, around 125 staff members at the time. And there was a handful of people who served as research subjects. And then there were photos of people that they would be looking at. 2/3 of those people were actually familiar to them and had, on average, worked in the same facility as them for 13 years. And the other 1/3 were total strangers. The photos were presented in very dim, the photos were taken in very dim lighting with hoodies on, all of the people shown in the pictures. So not ideal circumstances. And the participants were shown one photo after another and asked, do you recognize this person? And if so, who is it? And what was found was about 1/4 of the time when they were looking at strangers, they named someone from the facility. And so, yeah, I mean, people are good at identifying someone who's, quite familiar to them, but only if they can get a good enough view. And once you make the circumstances challenging, you get these sorts of misidentification errors, particularly, if people have a reason to expect to, to be looking at someone they know.
How does the Kerstholt study and the research regarding familiarity apply to Demoris Stepp and Michael Davis?
Well, the circumstances are remarkably similar, except that the Kerstholt circumstances were more favorable. So Demoris Stepp and Michael Davis both described their views of the perpetrator. It was under lower lighting than the people in the photos for Kerstholt, and it was a much briefer view than what the participants in Kerstholt got. And they were in a neighborhood that they associated with Mr. Dunn, and they both volunteered to police and to detectives, and then testified at trial that who they recognized was Mr. Dunn, someone they claimed to have some familiarity with.
And how does the clothing that they used in Kerstholt, how does that apply to Demoris Stepp and Michael Davis?
Thank you. Yeah, I left that out. So Mr. Stepp described the perpetrator, who he claimed was Mr. Dunn, as wearing a baseball hat. So under both circumstances, the study and also what Mr. Stepp claimed to have seen involved covering of hair and hairline, something called partial disguise in my field, something that's known to produce higher rates of misidentification.
And what about Michael Davis?
Michael Davis actually described a different form of partial disguise, also something that's been studied, though. He described sunglasses, and not only did he describe seeing sunglasses, but he he claimed that that is the reason that he knew it to be Mr. Dunn. He recognized him from the sunglasses.
You mentioned the phrase partial disguise. How do partial disguises affect eyewitness identifications?
They increase mis-IDs.
I want to talk about the opportunity that an eyewitness has to view the face. How do factors such as exposure, lighting, distance affect identifications?
Yeah, I think when you say exposure, you mean exposure time?
Yes.
Yeah. Well, we can go through these one by one. So you've already seen that given all the time you need in that matching task, you're still, if you're typical, have pretty good odds of making a mis-ID under the condition where you should have said he's not there. So now if we vastly limit your opportunity to view, we can, for example, show you a bring you into the lab, show you a simulated crime. This is something that Memon, M-E-M-O-N, and colleagues did during this simulated crime on a video. The participants actually saw a close-up, good view of the perpetrator for 12 seconds, much longer than what the record in the Dunn case reflects. And then during that same experimental session, about a half hour later, they were given a photo array, again, the right answer being he's not there, but 90% of people chose someone. You know, when you have a very limited view, when you are essentially precluded or really challenged from being able to form a stable, detailed memory for a face, the face of the perpetrator, then you are at high risk of finding somebody in the photo array to be good enough of a match to whatever it was you were able to put into memory.
And as far as lighting, how does low luminance or low lighting affect identifications?
Low luminance is clearly associated with not just lower rates of correct ID, but also higher rates of misidentification. It interacts with what we've just talked about because low lighting slows down the ability to extract information from a scene. So that brief glimpse just got worse if it's a very dim situation. And that's assuming that the lighting is good enough to see anything. I know that is a concern in this case, whether the witnesses were able to see the face at all. But under dim lighting, even if you are able to see a face, and even if you're able to see the face for several seconds, we know that that's associated with higher rates of mis-ID.
And what about the distance?
Misidentifications increase with distance, starting at about 25 feet under good lighting. What we know from research is that dim lighting effectively triples whatever the distance actually is. So that means as close as 8 or so feet away, we're starting to see a real drop-off in performance and a real risk of increased misidentifications.
How are these three factors, exposure to the perpetrator, lighting, and distance, how do those apply to DeMaurice Stepp and Michael Davis?
DeMaurice Stepp described himself as, glancing over, seeing a muzzle flash, recognizing Mr. Dunn in that brief glance before he takes off from the step. There's some changes in how he describes this early on. At one point, he hears the first shot, turns and sees what the record to me seems to reflect him claiming to be that first muzzle flash after he heard it and turned. Other things that he says and that officers put into the record make it possible that he heard the first shot, turned and saw the second muzzle flash, but certainly by the second muzzle flash, he's up and running away. So very brief glimpse. It's not of great concern to me which of those two it is because both of them fall squarely in extremely brief. Mr. Davis told police that he did not see the shooter at the time of the initial part of the attack, and that he ran either just, again, there's some discrepancies in how he reports this, but it's either just before or just after he fell, he looked over. And that's when he saw sunglasses. And from the sunglasses, declares that he knew it was Mr. Dunn.
What were the lighting conditions like described by Demoris Stepp and Michael Davis?
Not just those two. There was strong agreement across the record that I reviewed that it was quite dark. Mr. Stepp called it the darkest part of night.
And sorry, you said Mr. Stepp said that?
Yes.
Would that have been Eugene Wilson? Or sorry, you're correct, it was Mr. Stepp. Apologies. And Dr. Franklin, what was the moonlight like on May 18th, 1990?
It was a waning crescent moon, so it's, the last sliver of moon before it goes dark for the month.
And at trial, how far away did the boys testify that they were standing from the perpetrator?
At first, they said they were sitting. Both of them did. The initial description by both of the boys was that the shooter was on the other side of the adjacent house. I don't know how far that is, but it's certainly, more than that range of what we would expect very poor performance, particularly at night. And I'm sorry, one more thing to add is that given that Michael Davis described himself as seeing the perpetrator as he was falling, Mr. Davis had been running away. Apparently, my understanding is that the shooter was also running. So, I have no way of knowing that their distance was relatively maintained, but it still, from what I understand, was distant and potentially increasing.
Dr. Franklin, I want to go to Exhibit A, page 140, paragraphs 5 through 7.
Is Exhibit A here?
Yes, it is in a tab marked Exhibit A, but we'll show it on the screen here.
Okay.
So the question reads, all right, and about how far away from you was he, if you know? Answer, I'd say about 12, 13 feet. Did I read that correctly?
You did. This comes from trial. So this is a different description by Mr. Stepp than his original description of saying that the person was on the other side of, I think in the record it says 5709. I think that should be 5609 Labadee. So again, most of the Tolliver house is in that direction. And then there's the gangway, and then there's that whole second house. So clearly 12, 13 feet underestimates it. I think at this point, Mr. Stepp had changed his description and said that he had seen Mr. Dunn right next to the Tolliver house, right next to the porch, which is something like 12 or 13 feet away.
And assuming, and even if this statement were correct, that the shooter or the perpetrator would have been 12 or 13 feet away, how would the lighting conditions have affected that distance?
Yeah, it would have interacted with the distance and made seeing a face challenging. If Mr. Stepp had seen somebody who was standing at the corner of the Tolliver house, there was just, I believe, this one document in the record where he claimed to have seen Mr. Dunn clearly in that position.
Explain how event stress can increase the risk of misidentification.
Stress, well, it impacts eyewitnesses in precisely the opposite way that lay people often think it does. So it doesn't sear anything into memory. You don't have, the image like you can hit rewind and play and see it all over again. What happens is we have been evolutionarily adapted to respond to high stress, to life-threatening situations by having cognitive processing be redirected towards survival-oriented issues. Again, where do I hide? Where do I flee? How do I defend myself? Not what's the color of the person's eyes. And so what we find is that eyewitness memory for what the person looks like gets worse.
What studies have tested event stress in a sort of more realistic setting?
Yeah, it's been studied in the lab by several people using different methodologies, and we see the outcomes replicated across different labs, which is good to see, and it's the standard that we hold ourselves to. And as I mentioned before, that's one of the things that we can't really simulate very well when it comes to the lab comparing to real-world criminal circumstances where people's lives really are at risk. But there are a couple of studies that sort of piggyback on top of real-world stressful situations. And for example, Charles Morgan at Yale has spent his career investigating the impact of stress on military personnel. And the impact in all different kinds of performance, one of which has involved memory, and specifically memory for people. And so he works with the military, making use of the kinds of highly stressful training programs that they routinely subject their personnel to. So for example, let's say you're about to be deployed overseas. It's likely that you will undergo a very realistic simulation where you're out in the woods trying to evade capture. You're going to get captured. You're brought into a cell and held there. And at some point, you're taken into an interrogation room with a single interrogator and good lighting. And it's a stressful interrogation. You might be slapped. You might be thrown against the wall. You might be put in a high-stress posture. And the trainees are, the intention is to stress them out. That's the goal of this training, and it's very effective. It also has occasionally led to very serious injury. So it's realistic to some degree. So there's 40 minutes of interrogation under good lighting with a single interrogator, and then a day after release, the people who were subjected to this training are brought to a room where trainers from this facility are at the front of the room. You either have encountered one of them before or none of them before as your interrogator, and your job is to say either who it is or that he's not there. And even under these circumstances of 40 minutes of interrogation and being tested the next day, high stress led to about 60% mis-IDs when the right answer was he's not there. So what we find, again, is that the lab studies show impairment, but not to the degree that realistic simulations do.
How does event stress and the Morgan study apply to Michael Davis and DeMaurice Stepp?
They were present at the time of a shooting, multiple gunshots, both shortly after this began, saw their friend fall to the ground. Both of them ran themselves, suggesting that they believed that their lives were at risk. Yeah, so that, is exactly the sort of situation that we would consider very high stress.
Dr. Franklin, you talked earlier about your research into weapon focus. Can you explain a little more what weapon focus is and how it affects eyewitness identifications?
Yep. Again, several studies have been conducted. There are a couple of what's called meta-analyses, again, sort of looking at the totality of the studies individually, but also with a meta-analysis, we can take the data from all of these and using sophisticated statistical techniques, be able to speak about the strength of the finding, the pervasiveness of the finding. It's sort of the gold standard in any scientific field. And under all of the various kinds of circumstances that have been studied, most of which have involved guns, we find that misidentifications, eyewitness descriptions, memory for the person's appearance suffers when a weapon had been present at the same time as a face.
How does the weapon effect relate to DeMaurice Stepp and Michael Davis?
They were aware that there was a gun. Mr. Stepp described seeing at least one muzzle flash, and at least by the time of trial, he was describing that he saw a nickel-plated gun, which suggests to me that, well, first of all, I would expect that a muzzle flash in the dark would draw attention. And the description of a nickel-plated gun in the hand of a perpetrator also suggests to me that that is where his attention and cognitive processing were directed during the moment of that flash. That's typical of weapon focus effect, is that people are in a position to be able to describe the weapon. It doesn't make them a great, accurate eyewitness overall. It reflects that cognition is directed in there and not to the person's face.
Dr. Franklin, putting all of these factors that we just discussed together, how high was the risk of misidentification in this case?
Yeah, I can't, it would be irresponsible to put a number on it, but the confluence of perceptual conditions here, and also the kinds of statements that I saw in the record early on by these witnesses reflect very strongly to me that the ability to effectively see the perpetrator's face in sufficient detail to be able to put a stable, representation into perception and memory. I lost track of the beginning of that sentence, but it was very low. That the risk of misidentification was quite high. Again, harking back to the Kirstholt study, very poor perceptual circumstances, and as we see in the record, some basis for being able to make inferences, right or wrong, about who it might have been who you didn't quite see very well. Those sorts of circumstances appear to be present here.
Dr. Franklin, in preparing your opinion, you discussed that you reviewed the habeas and trial transcript in this case.
Yes.
You also reviewed the police report.
Yes.
And you also reviewed the tape statement of DeMaurice Stepp along with Mr. Stepp's affidavit.
Yes.
And did you also review a memorandum from the Attorney General's office of an interview with Mr. Stepp?
I did, yes.
Dr. Franklin, in preparing for your testimony today, did we discuss a chart that summarizes the information in the record that you reviewed in coming to your opinion?
Yes.
Dr. Franklin, on the screen, I have a presentation that starts with DeMaurice Stepp's statements. Is this the chart that we looked at?
Yes.
And that summarizes the record that you reviewed in forming your opinions?
Yes, it's not populated yet, but yes, this resembles what we discussed.
If we could see this before it's displayed
Yes.
to the witness, just so I can pose my objection.
And Judge, I have a copy for you as well.
Okay. You may. Thank you.
And And Your Honor, I would move to admit this as a demonstrative and summary exhibit.
Okay. I'll give them a second to take a look here. Okay, it'll be admitted as a demonstrative and summary exhibit. You may proceed.
We admitted 47.
46 is already in. This is 47, yeah.
Dr. Franklin, in reviewing the materials that you relied on, what inconsistencies in Demora's step statement did you find in what he saw that night?
His first description, or his first statement was in response to the question, did you see what direction that, the gun or the bullets were fired from? And he answered no, sir, to that, which reflects to me that he did not see the shooter shooting at any point during the attack, and that he did not see a muzzle flash at any point during the attack, because then, even if he didn't see the person holding the gun, he would know the direction that the gun was being shot from.
And how did this initial statement evolve in Mr. Stepp's statements?
Well, shortly afterward, he was asked, the question isn't on here, but he was asked, did you see Mr. Dunn prior to the shots being fired? So very direct question that he would come later to answer at trial the next year. He would say that he had seen Mr. Dunn a few minutes beforehand. But the direct answer to a very straightforward question, did you see Mr. Dunn prior to the shots being fired, was he was shooting the gun.
And how did that then evolve?
It evolved by the time of trial. I heard shots and I seen firing over my head. And so at that point, he claimed that a bullet came within an inch or so above his head. He claimed that he saw a muzzle flash. Again, there's some discrepancy. At trial also, the detective, Stum, testified that Mr. Stepp had said that he heard he heard the gunshot, he turned and saw the muzzle flash, and then there was a second shot. So again, the sort of physics doesn't work out here of seeing a muzzle flash from a moment ago. It's got to be gone by then. But so that was the testimony. And I'm sorry, the testimony by Stidham at that point was that's when he saw Mr. Dunn. So his statements of what he saw or whom he saw clearly did not include seeing Mr. Dunn or the direction from which Mr. Dunn was firing until trial.
And continuing through the chronology, how did Mr. Stepp's...
I'm sorry, I want to correct myself, because of course, on May 19th, he had named Mr. Dunn. I'm not saying that he first volunteered that he saw Mr. Dunn at trial. He did before, but the perceptual circumstances are not supporting it at this point.
And how did those statements evolve over time?
Well, at trial, again, Mr. Stepp claimed now for the first time that he saw Mr. Dunn 3 minutes before. By the time of his 2005 affidavit and afterwards, he's changed his claims again. So on October 21st, 2005, which is an affidavit, at first I didn't see anyone, then I heard more shots and ran. On May 11th of 2017, I didn't actually see Dunn with a gun. and he doesn't know who shot Rogers. So now retracting his earlier claims that he had seen Mr. Dunn as the shooter. And then finally at the Rule 91 hearing, May 30th of 2018, did you see the person firing the shots? No. He saw, again, he's claiming that he saw a muzzle flash, and that's all he's claiming at this point to have seen.
And Dr. Franklin, I apologize. I'll bring you a demonstrative so you can view it at your spot.
Thank you. Thank you.
Now, Dr. Franklin, in reviewing the materials that you relied on, how did DeMorestep's statements evolve as regard to the number of shooters?
That changed remarkably over time. At the time of the incident itself and at trial, he claimed to have just, seen and known about one shooter. By the time of his affidavit, which was 15 years later, he now, for the first time that I saw in the record, was claiming that there were 4 people, as opposed to the original claim of 1, who were shooting at them. And he also, in that same affidavit, said that there were 4 people now, or 5, on the stoop. So he's changing the situation quite extensively. And in 2017, he claimed that, and by the way, this is in the notes of his interview with the representative of the Attorney General's office. He now was describing seeing 2 people, and the person who was not Mr. Dunn was the one with the gun.
Dr. Franklin, in reviewing the materials that you relied on, how did DeMorestep's statements about the visibility that night change, if at all?
Well, so again, we know quite a bit about the perceptual circumstances that night. In his first interview with detectives, this item on the far left is actually in response to the question, how did you know it was Mr. Dunn, or Christopher Dunn, however the question was put. It was, how did you know it was him? And his answer was what I would consider to be a remarkably hedged statement. I looked at his face, but you know how you see somebody and you don't see him, that is an expression of the inadequacy of his viewing of whatever it was that he saw. And, I'll leave it at that. Over time, he continued to acknowledge that it was dark out. It was dark, it was the darkest part of night. That was a question by the prosecutor, and his answer was that indeed it was the darkest part of night. There was no question brought out about whether the porch light was on, and so it fits that it was as dark as the several people had described it as. And then going forward, he referred to the very dark circumstances as part of the reason why he couldn't see the shooter.
Dr. Franklin, in reviewing the materials that you relied on and coming to your opinions, how did DeMorestep's statements about the gun evolve over time?
Well, he didn't describe it specifically as nickel-plated until trial. And this actually fits with, potentially the evolution of a witness's description of what they saw, where they were, how good their viewing circumstances were over time as their experienced memory develops and becomes sort of richer and more cohesive. So the initial description, I'm not even sure from that original police report in 1990 whether he was claiming to have seen a gun. I mean, it was clear there was a gun at the scene, and the police report reflected that it was of unknown caliber. So I don't know that at that point there was any claim of seeing it. By the time of trial, he was claiming to have seen it and he could describe it. And then following the trial many years later, when he retracted that he had seen a gun as well.
Now, Dr. Franklin, even if we assume that DeMaurice Stepp was telling the truth at trial and that he did see a nickel-plated weapon, how would that apply to your research and the opinions you formed?
Yeah, so that would bring in the weapon focus effect and create the likelihood that if he was able to see the gun during that muzzle flash, that was what he was looking at and what he was able to see.
Dr. Franklin, in reviewing the materials and coming to your opinions, what statements by DeMaurice Stepp, how did DeMaurice Stepp's statements change regarding his relationship with Christopher Dunn?
Yeah, it wasn't just his own relationship with Christopher Dunn. It was that first question asked about whether anybody had any problems with him. And his response, again, this is, that first interview, May 19th of 1990, was within 3 hours of the shooting. And his answer was not that he knew of, that anyone had had any issues with him. And then there was reference the next day to the possibility or, the claim that one of DeMaurice Stepp's friends had a conflict with Mr. Dunn, but that he ran away. I'm guessing the claim was that Mr. Dunn ran away and that conflict didn't come to fruition as a violent interaction. At trial, he again asserts that he never had any problem with Mr. Dunn. And then many years later, 27 years later, speaking with the Attorney General's representative, he referred to Mr. Dunn having disrespected Rico Rogers' mother, and that Rogers responded by punching or slapping him. Finally, at the Rule 91 hearing, he didn't recall anybody, so I'll read it. I don't recall anybody else, but I know as far as myself, I didn't have any problems. There was in the police report at the time of the incident evidence that the boys were aware of or had belief about that Mr. Dunn had recently been released from custody about a month before, and a belief that he belonged to a gang that was a rival to the gang that they themselves had affiliated themselves with.
And Dr. Franklin, in the materials that you relied on, how did DeMaurice Stepp's statements about the location of the shooter change over time?
Initially, he described the shooter as coming from the location actually consistent with the crime reconstruction, crime scene reconstruction expert, that he had come from the west side, so the far side of the adjacent property, which here is listed as 5709 Labadee. I think might be referring to 5609. That's the White House that was shown in the crime scene reconstruction video. Michael Davis made the same, gave the same description. So it's consistent that he had come from all the way on the other side of that adjacent house. And then by the time of trial, again, consistent with an eyewitness whose memory evolves to make them seem like a better witness, right, that they got a better view. At trial, he, for the first time, reported that he had seen Mr. Dunn a few minutes before in the gangway, really just next to the porch that they were sitting at the corner of that porch.
Dr. Franklin, looking at all of these inconsistencies over time, how did those inconsistencies affect your opinion?
Well, so let me first say that what I care, what I used in determining the unreliability of their identifications were the early statements. You know, the police reports, the interviews with detectives. I certainly was interested in the claims that they made at trial. So that's what I relied upon in making in developing the opinion that they were unreliable. From my point of view, the claims and statements going forward might help inform how some statements evolved over time, might put some of the initial claims and claims at trial in context. But again, I was looking at the initial 1990 and 1991 statements. You know, you see someone and you don't see them. That was the basis for Mr. Stepp recognizing Mr. Dunn. That is such a red flag for an unreliable identification. And as far as Mr. Davis, how did you know it was Mr. Dunn? The sunglasses were pushed up against the face. So that's relying on an item of clothing that you associate with someone, relying on seeing sunglasses in what appears to have been pitch black or close to pitch black circumstances, and not relying on the appearance of a face in making an identification. Again, a very strong red flag, very strong, you know, unreliability. So I hope I answered you.
You did. Thank you, Dr. Franklin. I want to talk about witness inference that you referenced at the beginning of your testimony.
Sure.
How does witness inference and self-suggestion increase the risk of misidentification?
Yeah, well, I mean, we are very sophisticated cognitive beings, and we make meaning of circumstances that are partial or, you know, are challenging in terms of perceptual circumstances. What we do is fill things in, you know, make inferences very often immediately in the moment to try to create sense out of what might be, you know, insufficient information coming from the world. And that actually is what, you know, the Kirstholt study is about, where people were looking at dimly lit, you know, photographs of people wearing hoods, and were trying to make sense of who this could be, and doing what humans do very well, which is to, you know, sort of make inferences, fill in details that may not actually be there, and, you know, draw a conclusion that makes sense to them.
And how does witness inference and self-suggestion apply to DeMaurice Stepp and Michael Davis?
Again, there was already, I'm going to say knowledge, but really belief in the neighborhood, because I don't know, I know that Mr. Dunn had recently been incarcerated and recently been released within the previous month. I don't know whether he actually was a member of a rival gang, but it doesn't matter whether he actually was. What matters was the beliefs of these kids. And if that was part of their beliefs at the time of this attack, that could have been a basis for making the inference that it was Mr. Dunn.
And these inferences in the research, how quickly can those inferences happen?
They can be immediate.
And why is that?
Why is that?
Yes.
Yeah, well, that is how we are designed. We're designed to interact with the world effectively, efficiently, rapidly, you know, filling in even details that we're not aware we're filling in, drawing associations that may not actually be true, but we're sort of making our way through life using this, again, very sophisticated, but, you know, sometimes error-prone cognitive system. And yes, it can happen in a moment. It can happen during perception. It can happen in the seconds after an event is completed very easily.
Dr. Franklin, I want to talk now about how post-event suggestion can influence eyewitness identifications. How can it?
Well, that sophisticated cognitive system is full of holes. That's why we rely so heavily on inference, is because, you encounter a situation, you perceive only some subset of detail, only some subset of that makes it into memory, and then forgetting sets in immediately. And so, we are full of holes and fill in a couple of different ways, one of which is our own inferences. But we're also very strongly inclined to incorporate details that we encounter after the fact. So, you and I experience a situation, maybe I didn't see everything, maybe you didn't see everything, but maybe there were things that you saw that I didn't, and so on. And so we, inform each other, maybe with details that are inaccurate, but you and I both will just do our best to create as complete a representation as possible. And this goes on continuously, again, because memory is decaying over time, so holes are reappearing, but also, as we discuss the situation or as we encounter new information from any source, including something as innocuous seeming as a question by a detective, but that question containing some given that I may not have believed before, right? I might incorporate those details. The rub here is that we're not designed to tag every detail with where and when it got put into memory. And so, we sort of own all of this cobbled together memory as being our own. We tend to really buy into it and believe it. So, we're designed for, the kind of interface with the real world that's different from a courtroom where we have to say what was true at a given moment in time. That's something we're not good at.
And you talked earlier about kind of a dialogue that two people who witness something can have. What is the word for that in your field?
Yeah, it's co-witness influence, or what the field is usually called is co-witness contamination, because as we talk, I'll be incorporating details that you said that were not in my original memory. And eventually we will provide testimony that can strongly corroborate each other and make for a very compelling case, when in fact we've simply influenced each other and trained on, the same outcome.
And for DeMaurice Stepp and Michael Davis, in the materials you reviewed, was there evidence of co-witness contamination?
Yeah, in a couple of ways. One is that the statements from people who were at the scene reflect that Mr. Stepp was the first person to announce that it was Mr. Dunn, or, according to one person, maybe it was Mr. Dunn, or it probably was, something like that, sort of telegraphing that it's an inference and not a perception. And also Mr. Stepp testified later that he had told Mr. Davis to say that it was Mr. Dunn. So that's one thing, that the older person who who the people at the scene may have believed had a better view for some reason, and who was, seemingly authoritatively announcing who the perpetrator was, may very well have influenced the younger person. The second way that I was concerned that there may have been co-witness contamination was at the point of the photo array. So one of the boys, appropriately, the two boys were given the photo array separately from each other. And as is common from my experience, when an identification is made, the photo is flipped over and the witness signs the back. The researchers in my field, the American Psychology Law Society, admonishes very strongly to not let one witness know that another witness has identified the same person, because that bolsters their belief. It bolsters their belief. It increases their confidence completely artificially. Yes, the other person identified the same guy. And in this case, I don't know who signed first, but both signatures appear on the back of the same photo. So whoever went second got that positive feedback that the other person had made the ID.
Dr. Franklin, I am now showing you Exhibit 6. Do you recognize this photograph?
Yeah, that's Mr. Dunn's mugshots.
And is this part of the photo lineup that Michael Davis and Demoris Stepp were shown according to your review of the record?
Yes. Each was shown a photo array consisting of 4 different people, one of whom was Mr. Dunn.
Turning to page 6 of Exhibit 6, and apologies, Your Honor, Exhibit 6 has already been admitted. Is this the back of the photograph that you just referenced?
I'm going to say yes. I don't need to turn to Exhibit 6 because I'm familiar with this as the back of Mr. Dunn's photo.
So, Dr. Franklin, now that we're talking about the photo lineup, and you mentioned some of the best practices by your organization, what are some other best practices that your organization recommends?
Yeah, there have been 2 white papers released by the American Psychology Law Society. I'll refer to it as APLS, but it's the American Psychology Law Society. 2 white papers which are published in order to provide recommendations to law enforcement about ways that contamination of witness evidence can be reduced. The first was published in 1998, so that's 7 years after Mr. Dunn's trial. The second was published in 2020. And there are several recommendations. For example, in an ID procedure, the person, not just the person who's administering the ID procedure, but any person in the room with the witness should not know who the suspect is. And this follows from a large literature showing the incredibly easy ways, even with very subtle actions, that witnesses can be influenced during an ID procedure. To make an ID when maybe they wouldn't have otherwise, to identify the suspect in particular, to steer away from a filler in the array that they may have actually been favoring before the what's called non-blind officer exhibited some behavior that would change their mind. So blind procedures, right? Again, not knowing who the suspect is. Appropriately selected fillers. So here we have Mr. Dunn and 3 other people in the photo array. What it means for them to be appropriately selected, they're there to draw spurious responses away from a suspect, so that we're not guaranteed that everybody's just going to go ahead and say yes, that's the guy. So we surround the suspect with other people, but the caveat here is that they should be selected so that the suspect doesn't stand out in any way as the clear, best candidate. Witnesses should be given instructions before they're shown any sort of ID procedure that reduce the likelihood that they will make a misidentification. And those instructions are, you can say that you don't know, don't expect the perpetrator is necessarily in the set, don't ask me, don't expect I know. The investigation will continue whether or not you make an identification. So all of those are recommended. And a confident statement should be elicited immediately in an unbiased way, in the witness's own words, and memorialized immediately.
When you say a confident statement, can you explain a little more what you mean by that?
Yeah, so the witness can say, they can pick a filler, they can pick the suspect, they can say he's not there, or I don't see him. And what the confident statement is, as simple as how confident are you in the response that you just gave. And that response, again, should be memorialized in the record immediately. The reason for this, a couple of reasons. One is that under circumstances where an ID procedure is conducted appropriately, which is actually a rarity in real-world criminal situations where we have pristine circumstances where there's no biasing factors present. Under those circumstances, a highly confident identification in the first ID procedure is actually a reflection of a high likelihood of accuracy. So, that's a good thing to find if we have a guilty suspect, everything's been done appropriately, and a witness declares confidence in an ID. Other sorts of responses that a witness might give are also diagnostic of, unreliability, or, we can see how the confidence evolves over time. So that information is actually very helpful for evaluating reliability. It's also really important to sort of lock in what the witness says at the beginning, because we tend to see witness confidence continue to inflate over time, simply as a result of their exposure to the suspect and to interacting with police and getting feedback, and then it stays confident going forward. So we expect witnesses for the rest of time to keep asserting, yes, it was him, and I'm perfectly confident. So those are the recommendations from the 1998 paper. The 2020 paper added a few more. So for example, never subject a witness to more than one ID procedure involving any given suspect. If you do a photo array, that's it. Don't also do a lineup. The in-court identification, there's a whole set of issues with that, because that's a highly suggestive single-person presentation. But it also follows from a previous identification typically, and so the APLS considers that non-diagnostic. It's that first ID procedure that matters most. Fillers, not only should they be appropriately selected, but there should be at least 5 of them to appropriately protect a suspect from a spurious identification. And I'll just say one more thing, which is the recommendation of the initial interview being complete, right? Before the witness is exposed to any photo of the suspect, the first thing you want to do is sort of the equivalent of bagging the evidence. With a fingerprint, you sort of, put, I don't know, cellophane around it, I'm not sure, but you lock in the best information that you can gather in totality. You get you get a full description, for example, of the person that the witness saw, and you videotape the entirety of that interaction.
And Dr. Franklin, I think you might have touched on it a little bit, but as part of these best practices, are officers supposed to get a description of how are officers supposed to go about selecting the fillers? How do they decide which fillers to use?
The appropriate way to select fillers is to match the witness's description of the features of the perpetrator as closely as possible, while also not making the suspect stand out in any way. But the best way to make sure the suspect doesn't stand out as the clear best match is to know what features you're looking for when you're picking your fillers. So that comes from a description.
And Dr. Franklin, how did the procedures in this case align with the best practices that you just laid out?
Well, the photo arrays for both boys and the lineup, there was only one lineup conducted. It was for Mr. Stepp. Both of those were conducted by non-blind officers who knew who the suspect was. Both the photo array that was given to both boys and also the live lineup had only 3 fillers. And I saw no record of any description by either of the young boys of what the perpetrator looked like. So it's unclear to me whether Mr. Dunn may have been the best match to some feature that the boys associated with that name. Whether or not they actually really knew well what Mr. Dunn looked like.
Dr. Franklin, I just have a few final wrap-up questions.
Sure.
Everything that we've discussed today, what of this research would have been available to Mr. Dunn in 1991?
In 1991, this field was in its relative infancy. So, looking back through the entirety of the 1980s, fewer than 60 research articles on any form of eyewitness memory, including identification. Fewer than 60 were published in that entire decade. What we know about the impact of stress has changed quite a bit from the time of trial. And I'm saying that one first because, again, lay people, without being advised about what stress actually does to memory, can tend to credit witness testimony from a highly violent, personally salient, emotional event. Weapon focus, which is related to stress, was something experts had not yet fully, come to embrace. Our understanding of various forms of post-event influences had not been well known yet. Most of the research by 1991 was actually on correct identifications. I don't know why, but my colleagues who did that research before 1991 largely did not collect data on the risk of misidentification, which since then we've seen to be remarkably high under conditions that reflect real-world criminal situations. And for that matter, most of the research before 1991 were, here's a face, here's a face, here's a face, and then later on you had yes-no tasks, rather than people seeing simulations of actual crimes. And so, what's called ecological validity also made a major shift after 1991.
And Dr. Franklin, you mentioned as part of your review, you reviewed the recantations of DeMaurice Stepp and Michael Davis. Is that correct?
Yes.
Taking away those recantations as if you had not seen them in your review, would those affect your opinions at all?
Certainly not my opinions about eyewitness reliability. The statements made by them 2005 and beyond were where most of the statements that reflected pressure that they perceived to make identifications, the pushback that police gave when Mr. Stepp attempted to retract his identification in the moment in the 1990s. And Mr. Davis's description of being shown photos of the victim and having a call from the victim's mother and feeling pressure from those, feeling pressure because he was bought a plane ticket from California to come back and testify, and feeling the need then to be compliant. All that came afterwards. There was, despite all that, there was some information about incentivization of Mr. Stepp to testify against Mr. Dunn in the trial transcript, where it was raised that he expected a deal in an ongoing case of his own where he was looking at 30 years as a high end of his sentence. But setting aside the new issues around feeling pressured, no, absolutely not. I was relying on the statements made in 1990 and 1991 to draw my conclusion that this is a highly unreliable pair of IDs.
Thank you, Dr. Franklin. I have no further questions.
Thank you, Ms. Moore. Ms. Eastup, do you have questions for this witness? I do, Judge. Oh, you might.
Good morning.
The court reporter asked for a second. Okay. Good morning, Dr. Franklin.
Good morning.
You just testified, I think it was one of the last things you were asked about some claims that you saw on the record from witnesses that would have come post-identification. So I think you classified them as statements about coercion or pressure or perceived incentives. Is that fair?
Yeah, yes.
Okay. And in your report, whenever you reference those claims, you say, the evidence that you reviewed include claims that, if true, would present challenges to those identifications, in addition to what you had already noted, but specifically those claims, if true, would present additional challenges. Did I understand your report correctly?
Yes.
Okay. And so whenever reviewing the information, you accept it as true. Is that fair?
No.
Do you challenge it in any way?
No.
Okay. And want to talk about, you talked a little bit about receiving descriptions, law enforcement receiving descriptions of people they may or may not have seen.
No.
You didn't?
Not in this case.
You talked about that on your direct examination in general, about that's something that you look for, is if descriptions
Yes.
were given. Okay.
Yes.
And you said that you didn't see any facial feature descriptions given in this case. Is that fair?
Yes.
All right. There were some descriptions about what the shooter was wearing. That was the two boys, though. Is that correct?
Yes.
All right. And I want to talk a little bit about kind of what I'm classifying and maybe. So I first want to talk about lighting. And so, Dr. Franklin, you and I met very briefly in court yesterday as we were concluding for the day, correct?
Yes.
Okay, and so it's my understanding that you were in court. Were you in court all day or just for the afternoon testimony?
I don't know how to answer that. I flew in the morning, and I came in during proceedings. I came in during Eugene Wilson's testimony.
Okay, so sometime in the morning.
Sometime in the morning. I stayed through, and, to be fair, I had a very hard time understanding him.
Okay.
So I was here for at least some of that testimony, and I don't know how much I got of that. I was here for the entirety of the crime scene reconstruction testimony.
Okay, and in regards to Mr. Wilson, if you remember, did you get here before, during his direct examination, whenever someone from Mr. Dunn's team would have been questioning him, or when I was asking him questions?
I don't remember.
Okay, fair enough. So, you said that you were here for Dr. Roeder, for Mr. Roeder's testimony, though, correct?
Yes.
Okay. And in your report, you indicated that you talk a lot about the lighting. Is that fair?
I certainly discuss it, yes.
Okay, it's one of the factors that you considered as an important factor to your overall opinion.
Yes.
Okay. And I just want to make sure I understand correctly. So you talked about everything that you reviewed, and I won't have you reiterate that again. But from the voluminous documents and information that was available to you, you didn't see anything suggesting that there was a porch light on Marlon Tolliver's home where this murder occurred. Is that fair?
That's right.
Okay. And then I think you also note, you talked about this on direct, that you did some research to look up what the moonlight would have been that night.
I did, yes.
And then you also indicate in your report that there was no other source of illumination within several houses from the event house.
And I thank you for bringing that up. I learned yesterday that my view on, I guess it was Google Earth, was wrong, that I didn't see any streetlights, but the crime scene reconstruction expert testified to a light across the street and one house over, I think, and there was a light at the corner. Mr. Davis described that there was a street light, but not right there. That was the phrase he used.
Let me ask you, that's in the records?
That's in the record.
Okay.
Yeah. So I had not seen a street light. In my view on Google Earth, I guess it was last year that I looked.
Okay. And I think
it looks like I was in error there, and I
Okay.
apologize.
And I think, Doctor, I just want to make sure I saw report correctly, but I think you actually referenced doing your search on Google Maps.
Could
I
be
think they're
good.
different, so.
Yeah, that's how much I know. I mean, I'm very unfamiliar with this, and it might be why I missed a light post that was there, that I was, hitting the turn key and missed. I apologize.
Okay.
I did my best.
You're
and-
human, we make errors, fair?
Fair,
Right.
yes.
So, and I don't know, you may not have been here at this time, but, this exhibit isn't displayed right now, but were you in court whenever Mr. Eugene Wilson also marked on the map where those two light sources that you heard testimony about from Dr. Roeder, or from Mr. Roeder yesterday? Were you here when he marked those on that exhibit?
I was here for markings of exhibits. I couldn't, given where people in the audience are sitting, I wasn't able to see anything about where markings were made.
Okay, could I ask if that exhibit could be shown to this witness? Do you guys have that available, the demonstrative?
I think it's over there.
I'll wait. And I don't need the stand. Yeah, and I'm gonna bring it pretty close to you, doctor, just because the markings are quite hard to see.
Can we maybe lift it up on the,
Sure.
thank you.
Okay.
Can you guys see okay? Okay.
All right, and so, doctor, I'll kind of point you to the markings that Mr. Wilson made yesterday. So,
I would
Yeah.
object that I can't see any markings that Mr. Wilson made as far as where the porch lights were.
do you want to come closer? Sorry. I don't know how to do this. Okay, and so I'll point to you, you heard his testimony, but you couldn't see that. So you heard that he identified the home. Sure, yep. I know you couldn't see this because of the relative positioning of the demonstrative, but you heard that he identified the home here on Labadee where the murder occurred with this red circle. And then can you see the two black X's here that he marked referring to streetlights? And I don't want to overwhelm you with it, but I can bring it closer.
Yeah, my answer is no.
Okay, here, I'll bring it closer to you.
Judge, I would object that I can't tell where those markings are. They were made far too small for Dr. Franklin or anyone else to identify where he marked.
She can answer.
Well, he did make them, and I remember where he made them, so
Okay.
I'm gonna overrule it.
So I'll point to right there, that little X and that X right there. I said I'll point right, thank you. I'll point right here and that X, and I think there's a little blue circle around it as well, and then an X right there. Do you see that?
I do see that, yes.
Okay, thank you. I apologize for the
And
manner in which
actually,
I.
if you don't mind, I'd like to have this to continue looking at.
Sure. I'll just put it right here if that's okay.
May I stand?
Sure.
Thank you.
Oh, I'm sorry, I thought you wanted to look at it throughout your testimony.
Yeah, I might want to.
Okay,
So can you point to, for me,
Sure.
where the porch was?
great. Oh, it's this house right here. So,
Is that the house with the porch, or is that the abandoned
I'm
house?
sorry, I can't, is that?
I asked if that was the house with the porch or the abandoned house. He's pointing to the house on the left of two houses together.
Sure. All I can represent to you, Dr. Franklin, is that yesterday during his testimony, this is the house that Mr. Wilson identified as his friend Marlon Tolliver's home. That's all I can represent to you.
Okay.
Okay?
Thank you.
Yes. All right, and so Dr. Franklin, my question in regards to that demonstrative that we just looked at is your testimony and what you put in your report is you did not see those two streetlights whenever you were doing your kind of canvas of the area.
That's right.
Okay. And so those
And
would
to be clear, I didn't rely on my viewing of, the 2023 positioning of street lamps in evaluating the lighting at the scene. I relied on witness descriptions.
Okay, and so my question to you simply was that those two sources of, potentially sources of illumination were not something that you considered in your overall opinion.
I didn't consider them in my overall opinion, but I also didn't consider the absence of them in drawing my opinion.
Okay, understood. And so kind of still in this first category of factors affecting the encoding of an event or the real-time experience of an event. You also talked about distance.
Yes.
Okay, and I just want to make sure, and I understand you testified that there were maybe some differing statements about distance. But, so your report indicates that 6 feet is the optimal viewing distance for identifying facial features, is that correct?
Yes, 6 feet under good lighting.
Under good viewing circumstances?
Yes.
Okay, and then the identification accuracy drops quite rapidly once you get to 30 feet?
Under good lighting. And I also referenced research by Nyman, N-Y-M-A-N, I don't think I mentioned the author's name previously, that showed that under dim lighting, distances are effectively tripled.
Oh, I think you did mention that.
I
in your
did mention it,
direct
but not,
examination.
I didn't name the author.
And then, could the age of the person experiencing or encoding an event impact, let me rephrase that. When encoding or viewing a person's face, is it true that someone is more likely to recall or process facial features of those that are similarly aged to them?
There's a small research literature on this, but when we're talking about similarly aged, that research tends to compare, for example, young adults to elderly adults, not small differences between teens.
Okay, so does that also compare, young adults to elderly people? Like, are there more gaps than just different aged adults? Does that question might have not made any sense?
I couldn't follow you.
Sure.
You're
I'm going to rephrase that. You said that research focuses on young adults to older adults?
Yeah, typically. And
Okay.
again, it's a small research literature.
Okay. And so what about, I guess I'm not understanding, if it's similarly aged, is there a range of what is considered similarly aged as far as years go?
Yeah, I mean, if there were a bigger literature here, I'd be able to tell you more about what the findings show. But typically what we find in that area of research is that, as is true for so many other kinds of tasks, elderly people don't perform as well as younger people. But, elderly people can, overall, they're not as good typically, but they will do better if looking at faces of other elderly people than if looking at faces of younger people. It's similar to a different literature that's much better researched on cross-race identification, where, and also cross-cultural identification. I guess this is more similar to that, where people in a particular kind of cultural community differ from each other in ways that are different from how members of a different cultural community differ from each other. And you learn those nuances well for your own community. So that's why we see the cross-race impairment, particularly for older adults. I don't see that it applies here.
Okay, but just to make sure I understand your testimony, so the differing in ages is somewhat similar or comparable to cross-race identification because of what someone may be encoding, because what they're used to seeing or what they're familiar with.
Objection, compound.
Can you re-ask the question?
Sure. So you compared the kind of differing ages to cross-racial identification. And my understanding, and correct me if I'm wrong, is that that's because the identification or what someone is processing is different than what they're familiar with.
To some degree, yeah. I mean, it's a perceptual expertise that you develop over time. And so, for example, rather than cross-race, which this isn't as similar to as cross-cultural, let me refer to research by Sporer, Sporer, S-P-O-R-E-R, and Horry, H-O-R-R-Y, where white people from Turkey and white people from Germany viewed members of, all strangers, but members of each other's culture and members of their own culture. Again, everybody's a stranger, but you learn the dress patterns and the hairstyles and the kinds of ways that members of your own community, you learn the range. You learn, the kinds of specific features that tend to matter more within your community. You develop that perceptual expertise that you may not have so much for the other community. Again, I don't see it mapping at all onto the current case.
So you also, kind of the second stage, or at least what I'm calling stages, is then storing the memory or storing what you have perceived. And you talked about that on direct, and it's what I gathered from your testimony is a lot can happen to memory over time. Is that fair?
Yes.
And memory can fade.
Yes.
And your report largely focuses, or at least a large portion focuses on how seeing and hearing new information can impact a memory.
Yes.
All right. And specifically as it relates to eyewitness identification.
Well, in this context, yes, that's the context that matters.
Sure.
But
And you talked a little bit more about memory in general, but obviously the research that you were applying in your report focused specifically on eyewitness identification.
yeah, and it reflects the broader memory research.
Sure.
Yeah.
And so new information that an individual is exposed to could become incorporated into that original memory.
Yes.
And
Whether that new information is right or wrong.
Sure. And I think that you called that, I think it was post-identification events or...
Almost post-event influence or information.
Okay, I switched some words there.
Yeah.
And so basically, the stored memory and the new information become one. They're merged together.
The new information can influence the existing memory.
Okay.
Details can be incorporated. The details that get incorporated can be, can perfectly reflect the new information you were exposed to, or they can influence in some other way. Yeah, but there is certainly, this is a very large research literature on, it's also called the misinformation effect, how easily new information can influence memory and do it permanently.
And because of that, it's, and I think in your report you indicated it's often impossible for a memory expert such as yourself to determine what details come from the original memory and what of the incident and which details have been then incorporated after the fact.
That's right. That's why it's so important to see statements at different points in time so you can see the evolution and understand how memory is changing over time as a function of that.
And so that kind of phenomenon, it would be difficult for an expert, but it would also could be difficult for that witness to separate what came from the original memory and what came from the post-event suggestion. Is that
Exactly.
fair?
Yeah, a witness can be entirely sincere and entirely wrong. And again, it's the reason why you want to bag, again, to use that term, bag a witness's memory as soon as possible. So get the entirety of what they remember when it's at its freshest, when forgetting has had as little chance as possible to set in, and also, as early as possible before at least additional contamination might be introduced. And then you can see how it evolves from there.
And so talking about kind of the new information that potentially can be incorporated into an individual's memory from that experiencing the original incident, could that include photographs?
Could the post information?
Yes.
Yeah, absolutely.
and being shown pictures of a crime scene, could that alter or influence, if that's a better word, a witness's original memory?
Yes.
Okay. And specifically, if those photos contain different structures than at the time of the crime, like missing buildings or new structures, could that impact someone's original memory?
I suppose it could. So you're asking, for example, if a new fence and gate got put in, that people are,
Yeah, or
are
different-
inclined to,
Or different buildings? Basically, the landscape or layout of a scene has changed.
yeah, so the reason, one of the reasons that I'm hesitating is that, for example, specific to this case, we have boys who are well acquainted with the larger area before the event took place. So they would have had a clear representation of the house and its surrounds. And, you know, for those who remained in the neighborhood as structures were torn down or built or altered, you know, this becomes complicated very quickly, but to the extent that somebody knew the scene well, you know, we're not talking about where the body fell, because that's not something they could have known well before the night of the incident. But that would be a clearly held memory, although you just showed me that Mr. Wilson circled the abandoned house as the location of the porch.
And what about if the lighting is different in photographs? Could that potentially alter someone's memory of the circumstances whenever they experience the event?
Potentially it could, yes.
And then kind of the third stage, as I'm calling it, I'm certainly don't know if that's how it's categorized in your field, but the third stage is kind of retrieving that memory, being asked to retrieve or, I guess, recite, share that memory with someone else. So after, and I think you testified to this on direct, but after experiencing an incident, that forgetting sets in immediately. Is that correct?
Yes.
All right. And so in general, the shorter amount of time between encoding the memory and retrieving it, the better.
Yes.
All right. And here, I think you testified to this on direct as well, but you relied in forming your opinion more on those earlier statements given to law enforcement because of that phenomenon, that it's better to look at the shorter amount of time between encoding and retrieval.
Yes.
And you talked a little bit about stranger versus familiar face identification. I think you called that kind of a spectrum.
Yes.
Okay. But when it comes to eyewitness identification, stranger identification is the most error prone.
Yes.
And stranger identification is very easily impaired, and perhaps more easily impaired by those kind of different factors we've talked about.
Yes, and when I say stranger identification, if the perpetrator is a stranger, then you have a high risk of misidentification. That includes identifying a stranger as someone you know. And in fact, in the DNA exoneration cases, 15% of the misidentifications had involved people with whom there had been established familiarity between the people making the misidentification and the innocent exoneree.
And so there's a clear contrast between encoding or perceiving a stranger's face versus a face that someone is familiar with.
Yeah, given that you meet that bar that the scientists use for what truly familiar is, yes.
Sure, but you said sorry,
Truly familiar.
but you
Yeah,
said that's, sorry.
Truly familiar faces tend to be accurately identified under sufficient perceptual circumstances.
Okay.
There's that as well playing into this situation.
There's
that as well playing into that situation.
And so, stranger to a well-known familiar face, again, we can't, there's a spectrum.
There's a spectrum.
All right. And whenever identification of a familiar face is known in your field to be quite good,
Yes.
Close to perfect.
Assuming sufficient perceptual circumstances. Yes.
Okay. And identification of a familiar face is done automatically and quite rapidly.
Yes.
If you want to qualify that, under
I
sufficient
absolutely want to
circumstances.
qualify that.
Sorry, let me finish.
sorry.
It's okay. Let me re-ask the question. So identification of a familiar face would be done quite automatically and rapidly under sufficient circumstances.
Yes.
And a familiar face can typically be recognized given appropriate viewing circumstances. A familiar face can be recognized within a fraction of a second.
Yes.
Okay.
And you said appropriate viewing circumstances, sufficient viewing circumstances, sufficient lighting. You know, the witness at minimum needs to know what direction to look. And in the record, we see that Mr. Stepp initially said he didn't even know what direction to look in. You know, sufficient lighting, close enough distance so that a face can be discerned. And in sufficient detail, not just discerned as a detail. So sorry. Okay. Thank you.
Are you done with your answer?
I don't know. I can't
Okay,
remember my
I'll
answer.
ask a new question. How about that?
Sounds good.
All right, so you testified also about how sometimes partial disguise can impact, that's a factor. A partial disguise could be a factor in impacting the reliability of an eyewitness identification.
Yes.
Okay.
And researchers have demonstrated that, I mentioned Kirstholt, they are not the only researchers who've shown that partial disguise, even for someone who's been known for 13 years, can lead to misidentification. If you're looking at a stranger, you can misperceive that stranger who's wearing a hoodie as being someone familiar,
Thank you. I think
some
you did,
specific person. Yes.
you did talk about that research.
Yeah.
But whenever someone is processing the features of a familiar face, isn't it true that they focus more on the internal features of the face versus the external features like hair?
Yes, and under the circumstance where they're looking at a stranger who they come to identify as a familiar person, that's not going to be the case.
Okay, but it would be the case in the familiar face, that they would be processing the internal features.
To the extent that they can see them well. So again, I point you toward Kirstholt, where under bad viewing circumstances, where only the internal facial features are available, we're getting high rates of mis-ID.
So there are other factors impacting or affecting, let me rephrase that. There are
Sure.
other factors that experts in your field consider when looking at the reliability of eyewitness identification that you don't really discuss in your report in detail, perhaps because they're not present here.
That's certainly true. I mean, we know of dozens and dozens of factors that impact eyewitness ID.
Okay.
And so starting with that best of circumstances finding, where in a perceptual matching task you're making 1/3 errors, I do look for the factors that seem to apply to a case so that we can, you know, sort of draw down from that best performance.
Okay,
So-
and I want to talk about some of those other factors just
Sure.
briefly.
Yeah.
So really, I'm just going to go through them and ask you if that's a factor that is a factor looked at in your field.
Sure.
Okay?
Yeah.
Is a witness's eyesight something to consider?
Yeah, I don't know specific research on, you know, different eyesight values and eyewitness ID, but I can tell you certainly it would affect the ability to perceive and identify someone.
Okay, so that's a yes.
Well, you asked me, is it studied in my field?
Is it considered? Is that a factor that would be considered by
It
experts
could,
in
yeah.
your field?
Sure, yes.
Okay. And the weather conditions at the time a witness viewed someone?
It could be. If it was a blizzard, it would make it more challenging.
And any intoxication, fatigue, or other impairment by the witness at the time that they're viewing a person in question?
Yes,
And that's important because an impairment would make someone less available to recognize or perceive a visual facial feature, what they're seeing. Is that
yeah, I wouldn't
the
say
idea?
less available, but yeah, different forms of intoxication can impact perceptual ability and also decision-making function.
Okay. And then the time between, the passage of time between the person seeing an individual and then making an identification.
Yes,
And that's, we may have kind of touched on that with the retrieval aspect, but that's a factor that's considered.
yes,
We touched on this, but kind of in dicta with each other, but whether the witness and the person in question are of different races or ethnicities.
yes.
And then, obviously, you testified that that was not in play in this case.
I don't think I testified to that, but I didn't see any cross-race identifications here.
Okay, I think you mentioned it to me in an answer on cross a little bit ago.
I don't remember, but you're right. It doesn't, as far as I know, come into play here.
Okay, and Doctor, you've testified to your opinions as far as the reliability of identifications in this case, but you cannot speak to the accuracy. Is that fair?
That's fair.
Okay, and you can, because you don't know whether or not these individuals were accurate.
That's right.
Okay.
We can't know ground truth in real-world situations. Based on the evidence that I reviewed, I can't speak to the accuracy of the IDs.
Okay, so you can't speak to whether or not Michael Davis was wrong in his identification.
I can't speak to that. That's not my place as an eyewitness ID researcher. I can just speak to the quality of these identifications with regard to how predictive the IDs are of accuracy.
And
That's
you
what
can't-
reliability means.
Okay, and you're not offering an opinion or cannot offer an opinion as to whether or not Demora's step was wrong.
I can't, no.
And you don't know that if Christopher Dunn was the shooter on May 18th, May 19th, 1990.
I don't, no.
All right. And again, you can speak to you've offered testimony about the factors impacting reliability, but cannot opine on the accuracy of those IDs.
That's right, that's not my role.
I have nothing further.
Okay. Thank you for your testimony, Dr. Franklin. You may. Yeah, thanks. Should we do a sidebar real quick? I don't need you, Chris. Okay, we're back on the record. Mr. Shaw?
Yes, Your Honor. The circuit attorney lives.
Okay. So that's a good breaking point for us. At this time, we'll go to lunch, and I think we'll resume at 1:15. Okay, so we're adjourned till then. Okay, we'll go back on the record, and we are talking about some things at side. Really, I just did the sidebar to talk about logistics, but we got into some other things. So, and I don't think there's any reason that we should talk about them at sidebar since there's no jury here. So I think we can just talk about them now. Said.
I'm sorry, so the Attorney General does not intend to call Demora step. So my understanding, and Judge, this has all been discussed off the record. So the court had previously ruled in Lemonade that the Attorney General's proper witness, Tiffany Lindeworth, was going to be excluded to testify as to impeachment evidence. And so I'm asking the court at this time, while we're on the record, if that is the court's final ruling.
Yes.
Okay. And in light of that ruling, Judge, I would ask at this time to make an offer of proof in the form of calling Tiffany Lindeworth.
Okay. Does anyone from the other side want to be heard on this?
Judge, we don't know that it makes any sense to do that. In fact, they intend to do it for some purposes. First of all, it's our position, Your Honor, that they have no right to appeal here. But to be clear, we're perfectly fine if the court would simply be provided with a copy of Ms. Lindeworth's report. And I think that probably with Ms. Lindeworth's report or her memo, and I think that probably contains the testimony that she might give. And that would be sufficient, I think, for the court to consider a full record in the matter.
Okay. Is there a testimony or memo, Ms. Eastep?
Judge, just to respond to the first part of Judge Shaw's indication, I think that there is the right to appeal is a contested issue. That's for the court of appeals to decide. We are in disagreement as to whether or not we have a right to appeal. As far as making a record, I think that is best done by preserving the record so that the offer is actually a part of the record. So I prefer to call that witness. She did complete a memorandum in regards to her the contents of the statements. However, I think there are just some circumstances of the conversation where I would probably offer additional information beyond just what the witness said. Nothing extreme, but just, her position, who she is, how she related that to the witness.
Well, I want to recap this a little bit. So, you guys had Miss Lindeworth, and she went to talk to Mr. Shaw fairly recently, right?
Mr. Stepp.
Mr. Stepp, yeah, not Mr. Shaw, who's standing there. Sorry. Fairly recently, and that was not disclosed to the other side, and we did some legal jousting about that. But ultimately, what I said was that I am going to exclude her, and instead, what I would do, because I thought live testimony would be preferable, was bring Demora Stepp here, which I did, and he is here down the hall, and is available to testify to anything he would have talked to Ms. Lindeworth about. You guys writted me to the Court of Appeals and to the Supreme Court on that, which both denied the writ, and so that ruling stands. Not that they issued an opinion or anything, of course, but and I think I'm still going to deny the. Well, I am going to still deny the motion in limine, or exclude her according to the motion in limine. The question in my head is, A, is there any harm in doing the offer of proof? I don't know, maybe. B, do you guys have a right to appeal? My reading of the statute and the case law says no. I don't see anything in there. You guys aren't even a party technically, so I don't really know the purposes for the offer of proof, frankly. I think you guys think you have a right to appeal. I'm not sure that's right. but we don't have any guidance. And, just the act of bringing Demora's step here, we violated a statute in doing, as you know, because I put that in my order, and Judge Mason did the same thing in the Lamar Johnson case. So we're dealing with a new sort of proceeding here that doesn't have set limits to it. So I'm kind of wavering. So maybe I'll ask you, Mr. Shaw, do you see any harm in doing the offer of proof through live testimony, or do you see any harm, I guess, is my question.
The harm that concerns me, Judge, is that it appears that they may, whether intentionally or otherwise, attempt to taint the record by trying to introduce into the record evidence that they otherwise would not have been able to introduce. I understand that their stated purpose is to make an offer of proof, but an offer of proof can be made in any number of ways. It can be made by the representations of the attorneys involved, by a report of the testimony, by a transcript of it, or however the court sees fit to do it. So I don't see any purpose other than a purpose that is improper to offer this testimony live.
Okay, thank you. Ms. Eastup, I'll give you a chance to respond to everything that I just said and Mr. Shaw said. And
Sure, Judge. I don't think there's any harm in it because, as the court has already articulated, this is a new area of the law, and we don't have a lot of guidance. I think that it's appropriate, out of an abundance of caution, to make a record, and we have a right to preserve a record so that it exists, whether or not we have a right to appeal, which obviously there's some disagreement there. I think that because this is a bench trial, and there's still a requirement that courts receive offers of proof in bench trials or bench hearings, in addition to cases in front of a jury. But this court obviously knows what testimony and what evidence it can consider in its ruling, and so I certainly don't think there's any harm or concern from the Attorney General and that the court would consider evidence that it's not supposed to. But we have an interest in making our record potentially for appeal, just so it exists. We can't come back and do that again if we in the future sometime get guidance on that. And our preference would be to do that through testimony because I think that's the best way to preserve the record for any review court.
okay, yes, you may be heard. Sure.
Our position would also be that it's inappropriate to create an offer of proof for a rebuttal witness where they themselves aren't calling the witness. So the testimony of Demora Stum in 2018 is provided from a time when the Attorney General had the opportunity to cross-examine at that time. To have a rebuttal when they're not going to present what he would say now, we don't even know that it's appropriate to do so. So to have an offer of proof on a witness that shouldn't have been in under any circumstance without calling Mr. Step first seems inappropriate.
Okay, thank you. I think I'm going to kind of stick with my original ruling. I have offered you the opportunity to call Mr. Stepp, and you've declined that opportunity. So I'm going to allow you to make the offer of proof, but not through testimony, only through a written report. Okay?
Okay, Judge, with that ruling, I will offer what I have marked as Respondent's Exhibit Z, as in Z. And I'll offer that for the record to the court and to opposing counsel. Oh, and Judge, in addition to this written memorandum, the only thing that's not contained in here that I would elicit from Ms. Linderworth if she testified is just what her position is within the office and what she presented to Demora Step about her position whenever she's spoken. That is not contained in the memo.
Okay. Okay. I think that's fine. We're just going to stick with the memo, though. Okay.
And Your Honor, might we have a copy of the memo?
I'm doing that now.
Yep. Okay.
Sorry, First Judge.
Yes.
Just put this in our,
Just anywhere up there's fine.
do you want me to put in our binder with exhibit?
No, it's fine. I'll get it. straight and thank you, though. Do you have other witnesses you'd like to call, Ms. Eastep?
Yes,
We're ready for them then, I think, unless there's anything else.
Judge. Okay.
Okay.
Oh, Judge, just for the record, at this time, since this has been passed by the Attorney General, we would offer into evidence Respondents Exhibits A through T, as well as W. And I believe this is without objection based on my conversation with Ms. Houston, but no
Is-
objection, Your Honor.
To any of them? Okay.
To any of those.
Okay, A through T and W will be admitted. I'm ready for your first witness whenever you are.
Thank you. The Attorney General calls Gary Stum, and I'll just run on.
Okay. No. Just leave him back there till we're done. What you say? Okay, can we leave him there till we're done today? No, it's okay. We can let him go. Just let him go. He can go. So, will you raise your right hand? Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Do you mind being on camera, sir?
Repeat, sir.
We have some media here. Do you mind being on camera for your testimony?
Not afraid, no.
Okay. I'll take that as a yes. So I'm going to ask you just be kind of close to the microphone, actually really close to the microphone, and keep your voice up for everyone, and let the whole question be asked before answering, and if there's an objection, let me rule before
Gotcha.
answering. Okay? Thank you. You may proceed.
Thank you, Judge. Good afternoon, sir. Will you please state your name?
My name is Gary Stidham.
And Mr. Stidham, my understanding is you're retired.
I am retired
And where did you retire from?
from the St. Louis Metropolitan Police Department.
And whenever you retired from the St. Louis Metropolitan Police Department, how did you retire? What was your position, your last position with them?
I retired June the 2nd, 2011, and I retired as a sergeant of police.
And can you just briefly summarize your career with SLMPD for the court?
1978 through 1979, I was assigned to District 3. 79 to 84, I was assigned to Mobile Reserve. From 84 to 1987, I was assigned to District 4. From 1987 until 2003, I was assigned to the homicide section. 2003, I got promoted to sergeant. Did a short tour in District 8, subsequently returning back to homicide the latter part of 2003, probably early 2004. 2006, I was reassigned and returned back to District 8. From District 8, I concluded my tenure as a police officer, returning back to District 3.
Okay. And during the time that you were assigned to the homicide section, does that section cover the entire city of St. Louis?
The entire city.
All right. And the times that you were assigned to particular districts, and I guess in addition to your homicide, your experience in homicide, do you become familiar with different neighborhoods in the city of St. Louis?
Yes, you do.
All right. And in general, are there some neighborhoods, at least at that time, in the 80s, 90s, in the city of St. Louis that are known as more high crime neighborhoods?
Yes.
Okay. And in addition to that, were particular neighborhoods known for particular type of criminal activity?
Yes.
All right. And so I want to direct your attention to the Wells Goodfellow neighborhood. Is that a neighborhood that you are or were familiar with?
Very familiar with the Wells Goodfellow neighborhood.
And it's my understanding that the districts have been reallocated over the years in the city of St. Louis. What district during your time at SLMPD was the Wells Goodfellow neighborhood within?
District 7.
District 7, okay. And did you ever have particular assignment to District 7?
Outside the scope of mobile reserve, no.
All right. Whenever you were a detective in the homicide section, is that one of the districts that you would have investigated homicides in?
Plenty of times at District 7.
Okay. And I want to direct your attention to the early hours of May 19th, 1990. Were you assigned a homicide investigation at that time, so late, the early hours around midnight of May 18th going into May 19th of 1990?
Yes.
All right. And what was your role in that investigation?
I was a scene detective.
What does that mean when you're the scene detective?
And what that means is that I arrive and I assess the scene. If there's any items of evidentiary value, I will note that and pass that information on to the evidence technician. Outside the scope of that, I then conduct a canvass of the area looking for witnesses to see if anyone may have seen or heard anything relative to the incident that I'm investigating.
Okay. And responding as the scene detective, do you then become the lead detective of that case?
Yes.
Okay. And as part of your duties as the lead detective, do you compile a report?
Yes.
Is that report authored in its entirety by you, or do other officers contribute?
Other officers contribute to the report dependent upon what they're doing in the report. In this particular incident, I do believe that Sergeant Brown, he was a supervisor then, and he conducted a canvass, so the bulk of who he talked to, what they said, he would have typed that out and emailed that to me. Detective Scoville, she would have spoken, and she would have also, what the contents of what she did, she would have typed it out and emailed that also to me. So we would cut more like cut and paste and put it all together in one report.
Okay, so you become, in your role as the lead homicide detective, do you become aware of other people's pieces of their investigation?
Yes.
All right. And so where did you respond whenever you were contacted about this reported homicide or incident?
I believe that was in the 5600 block of Labadie, I think it was.
And what neighborhood is that in?
That is the Wells Goodfellow neighborhood.
All right. Does 5607 Labadie sound correct?
Yes, it does.
Okay. And did you have the opportunity to spend a lot of time in that neighborhood?
Yeah, I did. Outside of policing, I did a lot of outreach.
Okay. And I'm going to ask you about that, Detective, but specifically, did you investigate a lot of crimes in that neighborhood?
Wells Goodfellow, yes.
All right. And whenever responding to that neighborhood that night, and I'm kind of going to walk through your investigation maybe a little bit out of order, but at some point in your investigation, whether it's the first thing you do or not, I think you just testified that that would involve some sort of canvass of the area for potential witnesses.
That is correct.
All right. And in relation to your investigation of this incident at 5607 Labadie, did you interview an individual named Mr. Tolliver?
Yes.
Okay. And do you recall what you learned from Mr. Tolliver about what happened?
I believe that if my memory serves me correctly, that they were sitting on a porch, something to that effect, and gunshots started ringing out.
Okay.
And, gunshots started ringing out.
All right, and I'm going to give you a copy of Exhibit I, Respondent's Exhibit I, which is admitted into evidence, which is a copy of your police report, and I may ask you to refer to it throughout your testimony in case it helps refresh your recollection.
Sure.
You'll just bear with me 1 second. My apologies, Judge.
No problem. You don't have 8 people at your table like the other 2.
Can I first?
You may.
And you know what? I'm going to move this binder just so you have a little more room.
Here, let's do it right there.
Right there? Okay, perfect.
Yeah, that's fine.
All right, and Detective Stidham, I'll ask you to refer to page 4 of the actual report, not the front pager. And let me know when you're there.
Go ahead.
And do you see in the portion of your report where it identifies that you spoke to an individual named Marvin Tolliver?
Yes.
Okay. And what did you learn from Mr. Tolliver about how he learned about the incident?
It is as to what I wrote, is that Tolliver,
Yeah, I need to speak up.
Tolliver had indicated that prior to the shooting that he, Gino, and I guess it's his diary, were walking east on Liberty in the 5500 block. Suddenly they heard about 5 gunshots. At that point he ran home. He observed the victim lying on the front lawn. And it was advised by Damaris that Christopher D., a.k.a. Trap, had done the shooting.
Okay. And in addition to Mr. Tolliver telling you where he was when this happened and who Damaris indicated was shooting, did he also indicate to you anything about Christopher Dunn that the police would have considered as a potential motive for this shooting? And you can refer to your report.
Well, it's something to the effect that Christopher Dunn was indicated that
Sir.
he was a Crip.
Can you move the mic down a little? Because when you're looking at your report, there you go. I think that'll be better.
Indicated that he was a Crip. He had just gotten back from prison. And he indicated that he had known Christopher since grade school.
All right. And then I'll direct your attention to the next page, page 5.
Go ahead.
And did you also,
Yes, sir.
I don't object to the witness reading from the report, but can you make it clear in the record when he's reading from the report or when he's reciting from memory?
Yes.
All
So,
right.
do you have that?
Yes, Judge.
Okay.
Absolutely. And so, Detective Stidham, I'll direct your attention to the first it looks like the first individual identified on this page, I think you pronounced it Dari D. Do you see that?
That is correct.
And would this have been another individual that you spoke with during the canvass?
Yes, it was.
Okay. And I'll ask you to look at your report, and you can either look at it and see if it refreshes your memory or read from your report. If you could just let us know which one you're doing, and let me know what you learned from Dari D. about the incident.
I will read from the report.
Okay?
And he indicated to me that he, the victim, and Damaris were sitting on the front porch of the Labby location. It was at that point that they proceeded to walk east on Labadie when suddenly he heard 5 gunshots. At that point, Damaris ran from that location and advised Christopher D. was shooting at them. Dory then returned to the Labby location where he observed the victim lying in the yard, and he could add nothing further. He could add nothing further.
Okay, and then I'm going to turn you back to page 4, the one that you were just on. Let me know when you're there.
I'm there.
Okay. And did you also speak with an individual named Derwai Rogers or Derwai R?
Yes.
Okay. And again, if you could read from your report, and that's just fine, if you could tell us what you learned from Derwai Rogers.
Reading from the report, he advised that he was at his residence with Michael, and Dari appeared and advised that his brother had been shot by Christopher D.
Okay, and I'll ask you to flip to page 5 and look at the second paragraph of what you learned from Derwai Rogers. I think it's just at the top of the next page.
I'm here. He left his residence to investigate, and he located the victim lying in the lawn at the mentioned Labadie location.
You can keep going.
He concluded and stated that he observed Christopher D. during the PM of 5/18/90. During that time, he had indicated that he was a Crip and left the area. This is the first time that he had ever seen Christopher D.
Okay. And then, Detective Stidham, whenever you arrive on scene, are you the first responding officer, or would someone typically arrive prior to detectives?
In any given critical shooting or homicide, the district are notified to respond. The officers get to that location along with a supervisor. EMS, they're there. EMS was assessing the situation, and at one time, the district supervisor will switch over to the SOD channel and request that homicide respond. They will indicate whether or not the victim will remain or if the victim is being transported to a hospital, and if it is a hospital, what hospital.
And so in this case, whenever you arrived on scene, were there already officers there securing the scene and starting some
Yes.
sort of investigation?
There were uniformed officers present.
And do you recall who those uniformed officers were?
I believe there was a night staff commander. I think that was Captain Ballman. I think he was there. Ballman, B-A-U-M-A-N. There were the officers who got the initial call. I don't recall their names. And there was a secondary backup officer with him, and I think there were a couple of detectives that were there. I don't recall their names. There was a lieutenant that was there. There was a district precinct sergeant that was there. I don't recall his name. But altogether, that scene was secure.
Okay. And whenever you arrived on scene, did you speak with an Officer Reynolds?
Yes.
Okay. And Officer Reynolds, what did you learn from her about their initial response to the scene?
She indicated at the time that she got the call, what the nature of the call was about, and when upon her arrival, She observed the victim and how the victim was. I believe she spoke to the individuals that were present with the victim, held them until I got there. She then, after the victim was transported to the hospital, I do believe she placed a paper silhouette in the lawn.
Okay, and you indicated that she spoke with two of the individuals that were with the victim and held them until you got there?
Yes,
And did she indicate to you that those individuals had identified who the shooter was to her when she arrived?
yes.
And who did they? Well, if I'll just ask you to look at page 1 of your report. It looks like it's the 5th paragraph down. Are you there?
I'm here.
Okay. And what were the names of the individuals that Officer Reynolds spoke to on scene?
Damaris S. and Michael D.
And who did they indicate to her was the shooter?
Christopher D. They indicated to her that Christopher D. was holding in his hand an unknown caliber handgun, which he pointed in their direction and fired 4 to 5 gunshots.
And so at this point, Detective, once you're on scene and you learn of these identifications, do you then choose to further interview these individuals?
Those individuals both were taken to the homicide office.
And was the homicide office located at police headquarters?
Yeah, 1200 Clark.
Okay. Was that police headquarters back?
Yes, it was. I'm
Back then?
sorry.
Okay. And do you remember how they got to police headquarters?
I'm believing that Officer Reynolds conveyed them.
Okay, so you would not convey them yourself?
No.
And eventually, did you respond to police headquarters to conduct those interviews?
Yes, the conclusion of the canvas.
Say that one more time?
The conclusion of the canvas.
Okay, so you would have finished your scene canvas and then responded, and they're waiting for you there?
Yes,
Okay. And did you interview those individuals separately?
definitely.
Okay. And the first person that you interviewed, Damaris Stepp, did you learn how old he was?
Yes, I believe he was 14.
Okay. And what did he tell you he saw?
They were on the porch area, and talking. Gunshots rang out. As they took cover, he turned and he looked, saw the muzzle flash, and saw Christopher D. shooting at them.
And at that time, during that interview, did he indicate to you what the shooter was wearing?
He indicated a white hat, a white top, and I do believe some blue pants.
Okay.
Blue pants.
And Detective, I'll direct your attention, just so we're clear, to page 5. And it looks like it's the end of the second paragraph in relation to Damaris Stepp. I'll just ask you to read that last sentence, and I'll ask you again about what he was wearing.
Repeat that again, please.
Sure, the second paragraph under the Damaris Stepp section, that last sentence. 5.
In the 5500 block of Labadie, he advised Dari D. and Marvin Tolliver of the incident, at which time they returned to the Labadie location and observed the victim lying in the yard.
That's not what I'm looking at.
I'm sorry.
No, that's okay. So I'm just asking you to review this last sentence here.
Is that Damaris S. further stated he heard a second shot, which caused him to run to the east, subsequently jumping a fence at the yards of 5707 and 5605, Labadie, and run east into the 5500 block of Labadie.
And Detective, the sentence right before that paragraph that starts with Christopher D. was clad.
Repeat that again, please. Oh, yes. Christopher D. was clad in a white T-shirt and a blue baseball cap.
Okay, so I think you testified earlier that your memory was that it was a white T-shirt and a white baseball cap, but would this report be more accurate than your memory?
Yes.
Okay. And did you also interview Michael Davis at police headquarters?
Yes, I did.
And did you learn how old he was at
Yes.
that time?
He was 12.
And did he tell you what he saw?
Yes, he did.
And what was that?
He was indicated he was sitting with the victim and Damaris. Suddenly he heard a single gunshot and observed the victim fall on the lawn. As he fell on the lawn, he said his attention was directed to the lawn at 5609 Labadie. At that location, he observed a subject he identified as Christopher D. He further stated that Christopher D. was wearing eyeglasses, or correction, sunglasses, and a white T-shirt. At that time, he heard 3 additional gunshots, which caused him to lie in the lawn and play dead. While he was lying on the ground, he observed Damaris S. running east, jumping fences, and running from his view. After the shots had subsided, someone who was in the window at 5607 Labadie asked where the shots were coming from. He indicated from the next yard at 5609 Labadie.
All right, and after you interviewed these individuals, Damaris Stepp and Michael Davis, did you conduct any sort of identification procedures with them?
Yeah, I went and did a profile on Christopher D. I was able to obtain an LID photograph. That LID photograph was placed among a photo spread of people with similar facial characteristics with Christopher. That photo lineup, photo lineup, it was shown separately to each of those young men there.
So I'm going to ask a couple questions about that. You said that an LID, I think, profile was created. My understanding is those are automatic now. In 1990, was it done automatically?
No, it wasn't.
So who did it?
I did it.
Okay. And so how do you strike that? If you go to the system and try and pull up an individual, what do you do if there's more than one individual by the name in the system?
If it's more than one individual by the name in the system, we make the verification as far as how old that individual is. If it had have happened that way, I would have placed all of the individuals bearing that name and made a photo lineup of all of those individuals, so that they could just pick out who it was in a situation like that. So.
And so in this case, was there only one individual named Christopher Dunn?
That's all it was.
Okay. And so then you pick out individuals to include in that lineup or that photo array, is that correct?
Yes, I do.
And I'm going to show you Respondents Exhibit. Bear with me. G. I'll have you flip through that.
Does the other side have G?
Yes.
Okay.
And Detective, is this the photo array that you prepared for Damaris Stepp and Michael Davis?
It is.
And Detective, how do you know that?
Because they initialed the rear of the photograph there itself.
Okay.
And that's what I packaged it in.
All right, and you also complete this packaging?
Yes, I did.
All right. And whenever this photographic lineup, the way I have it is individual pieces of paper. Is that how it's presented to the witnesses?
Yes.
Okay, so one at a time?
Yes.
All right. And after you presented, or I guess during the presentation of these photo arrays to Demora Stepp and Michael Davis individually, who did they identify?
They identified Michael Dunn.
Christopher Dunn?
Christopher Dunn.
Okay. After, and again, I told you I'm going a little bit out of order, but down the road, I think the next day after Christopher Dunn was arrested, did you then request a live lineup or an in-person lineup?
That was after he was arrested.
Okay. And what was the purpose of doing a live lineup?
That's a procedure that we do. We show a photograph, but we have to, and once the individual is arrested, we place that individual into a live lineup.
And in this case, did only Demora Stepp participate in the live lineup?
Yes.
Okay. And where do at least in 1990 at SLMPD, where do witnesses view the live lineup from?
Second floor holdover of prisoner processing.
And so where are the individuals chosen from to stand in that lineup in addition to your suspect?
We inspect what individuals they have incarcerated. Again, similar to the photograph, an individual with the same height, same facial features, same hairstyle. We put them in a lineup like that.
And who selects the individuals to be in that live lineup?
I do.
All right. And so you would have selected the individuals in this case?
Yes.
All right, and I'll show you Respondents Exhibit H, as well as M, which is the same photo, just a little easier to see. And Detective Stum, does this appear to be a photograph of the lineup that you prepared for Demora Stepp in relation to suspect Christopher Dunn?
That is.
And who did he identify from that live lineup as the shooter?
The person in position 1.
All right. And Detective, to the best of your knowledge, are these photographs of the lineup, are those taken while the witness is viewing the lineup?
No.
What?
Afterwards.
Afterwards? Okay. So Detective, earlier you testified that you were pretty familiar with the Wells Goodfellow neighborhood. Is that due to your service as law enforcement?
Before I got into law enforcement, I was in outreach. I worked for the Human Development Corporation. And my first start within outreach was in the area of Pruitt-Igoe. From Pruitt-Igoe, I moved out to the... Pruitt-Igoe. Okay, and from Pruitt-Igoe, I ended up into the Wells Goodfellow area. Working within the Wells Goodfellow neighborhood, I also was a radio announcer, so I had two things going at the same time. But I dealt with a lot of youth within the Pruitt-Igoe area, as well as the Wells Goodfellow area. The concept is that a lot of kids have something to say, they just don't know how to say it. They don't know who to trust to even say it. So looking at the children like I did, I looked at them and I'm saying I'm understanding them because, there's something that they need to do. There's something that they need to be. They need a purpose. They need some sort of direction. They need some sort of guidance. Having lived that type of situation, my mother died when I was 5, and she died at an early age. So there was the concept of saying that I have to give something back because in my growth, I understood what the area was about. I lived in the West End, which was the south side of the Wells Goodfellow area. So I was familiar with the area, but the whole concept was that it was just giving something back to youth.
Okay. And did your youth outreach crossover with your law enforcement service?
It did for a while. Actually, when I went to homicide and within the caseloads, within the additional unit that I was in, I was a SWAT team member, and that was a lot of calls within that situation. So I had to cut that down as far as having to meet with youth in that area. And then there became a surge of homicides. I believe it was in 1989, and I think it was 93. I think the city of St. Louis had some close to 300 homicides within both of those years. So the workload was big.
Okay. And in fact, did you ever receive any recognition for your service in the area of Goodwell's Fellow?
1981, I received an Officer of the Year award from the Human Development Corporation with the Wells Goodfellow Center.
Okay. And based on your experience at SLMPD and your youth outreach with that neighborhood, are you aware of, particularly in 1990 or around that time, any gang activity in the Wells Goodfellow neighborhood?
Well, I attempted to search for a memorandum, but at that precise time, there was a memorandum that came about from the intelligence unit.
You said from the intelligence unit?
From the intelligence unit that indicated that there was a possibility of members coming from the California area, probably stopping in the Chicago area, working their way to the St. Louis and Kansas City area, as far as a recruitment type of situation is concerned. So these kids, they didn't know anything about being a gangster other than what they saw based upon what they heard. We called it a lot of perpetration.
What does that mean?
Well, they were faking like they were something that they weren't.
And how would they do that?
Oh, they would wear various colors. They would wear the red. They would wear their blues. Some people would wear black, pretending that they were gangster disciples. But there was no identification within that. It was just perpetrating.
So perpetrating as members of these gangs, but not necessarily affiliated with.
That is correct.
Okay, affiliated with the gangs in LA area.
Correct.
All right. And was that a root or cause of gun violence in that area?
Yeah, yes, it was. Among the drugs that were in the area. Yeah, it was a lot of violence there.
Okay. And on going back to the day of May 19th, 1990, later in that day, were officers eventually able to locate and detain Christopher Dunn?
Yes, they did.
And was that without incident?
Short foot pursuit.
Okay, so
Right.
some sort of evasion of arrest?
Yes.
And was he wearing a hat when he was arrested?
I don't recall.
Okay, I'll direct you to, if I can find it. Well, I'll direct you to, let me ask you this. If you seized clothing from, or items from Christopher Dunn whenever he was arrested or elsewhere, would that be listed in the property section of your report?
Yes, it would.
All right, that might be easier to look at. And I'll direct you to, it looks like maybe page 4 of the property list. And I can just come show you my copy.
I have it.
You have it? All right. And it looks like it's the second item on that page. Was there a hat seized from Christopher Dunn?
The Chicago Bears navy blue baseball cap.
All right. And I'm going to backtrack just a little bit and ask you, again in this property section, would the police also seize items from the victim from either, I guess, the hospital or the morgue or the ME's office?
At the hospital, there would usually be a uniform officer accompanying the ambulance. Those clothes are seized. They are marked and packaged and delivered to the laboratory.
Okay. And I'll direct your attention to page, it looks like page 6 of the property list.
Go ahead.
And that middle item, does that appear to be the list of clothing recovered from the victim, Rico R.?
Yes, it is.
And what color were his shoes?
Had red tennis shoes.
Did you, after he was arrested, did you interview Christopher Dunn?
Yes, I did.
And did he refuse to have that interview be recorded?
Yes, he did.
If a suspect refuses to be recorded, do you oblige?
There's nothing I can do except move on with the interview itself.
Okay. And during that interview, were you attempting to determine where he placed himself at the time of the murder?
Yes.
And where did he place himself in his conversation with you?
He indicated it earlier. He was with some of his friends there in the area. I think it was maybe 6:30. He had left the area and traveled to another location. With some conversation about going to, I believe it's Miss Young's house or something to that effect. And she had discussed with him that she had heard that he was in trouble. She had heard that he was in trouble, and he indicated to her that he didn't have anything to do with that. With that, I do believe that the police were coming to Mrs. Young's home. I think he went to the basement, subsequently leaving out the rear door of that location.
And Detective, I'm just going to stop you. So it sounds like you're describing his whereabouts the day of his arrest. Where did he tell you he was during the night of the murder? And if it helps to look at your report, it looks like starts on page 15. Near the bottom.
6.
Or really, Detective, I apologize. At the top of page 16, it looks like is when he gets to that night.
Okay. He stated he was at his residence at 10 o'clock and subsequently left and rode in Rickman's vehicle throughout the city, whereupon a group consisting of 14 to 15 persons whom he refused to identify had congregated at the east side of his residence. At or about 12 midnight, he went to the residence of Terry, and she is a black female no further, and he spent the night returning to the residence at about 7 a.m. of 5/1990.
All right, so he indicated to you that he was outside of his house from about 10 p.m. until 7 a.m. the next morning?
That is what he said.
All right. And at some point, Detective Stidham, did you respond to, in the early morning hours of May 19th, did you respond to Christopher Dunn's home looking for him prior to that arrest?
Sergeant Brown and I conducted an investigation at Christopher Brown's home in attempts to locate him.
Okay, you said Christopher Brown's home.
I'm sorry,
It's okay.
Christopher Nunn. I got things in my head.
And it's reflected in your report that that was around 2 in the morning, is that right?
Thereafter, yes.
Okay. And at that time, who did you make contact with?
The mother.
All right. And did the mother indicate to you whether or not he was home?
She had indicated, I'm trying to figure out which one of the interviews, because he was interviewed a couple of times.
Sure. So I'll direct your attention to the bottom of page 6 of your report.
She indicated that he had been in the house and he had left with 2 individuals, if I'm not mistaken.
And at that time, were you trying to ascertain if Mr. Dunn was in the home?
Yes.
Did she allow you entry into her home?
Yes, she did.
And did you look for Christopher Dunn?
We went and looked into his room and he wasn't there.
All right. At some point, did you or other officers seize some clothing items from Christopher Dunn's mother that she indicated he had on the night before?
Sergeant Brown conducted an investigation with her. She indicated to Sergeant Brown that the clothing that he was wearing, she had put him in the basement. I think she directed her daughter to retrieve the clothes from the basement.
And what the clothing items that she retrieved, was that consistent with what Demoris Stepp and Michael Davis said they saw the shooter wearing?
Yes, it was.
Right. And you talked a lot about your investigation and involvement with, or conversations with different witnesses. After concluding interviews, concluding at least the bulk of your investigation, is it common practice for law enforcement to take witnesses to the circuit attorney's office with them when applying on cases?
Yes.
And who typically presents a case to the circuit attorney's office to file charges?
Normally the primary investigator.
Okay. And in this case, who went to the Warren app?
In that case, Detective Liz Scoville went to the warrant office.
Was Detective Liz Scoville your investigation partner in this case?
I believe she was. I do believe I was off the day that she may have taken him
To the Warren app?
to the warrant office, yes.
Okay. And why is that common practice to take witnesses to the Warren office when applying on a case?
That's due to the fact that the circuit attorney may want to talk with them.
Okay. And in general, after a Warren application, if charges are filed, are charges always filed at Warren applications?
Not always.
Okay. Sometimes
Sometimes there's a TUA and there's a worksheet that is attached to it that is more work that the circuit attorney may want done. If a warrant has been issued, then the contents of that investigation is complete. And
Okay.
it becomes a part of the circuit attorney and their investigators.
Okay. And so after the Warren application, do you have any further contact with witnesses if there's an absence of a TUA work order?
No,
Okay. Are you ever involved in preparing witnesses for a grand jury
no,
or for depositions
no,
or for trial?
no. That all falls on the circuit attorney's investigator.
Okay. And Is that typical for all of SLMPD or just homicide?
That's typical for all of them.
Okay. Do you have any memory of interacting with Michael Davis or Demoris Stepp after the warrant application?
No,
If you had any contact with them, would you have included that in your report?
definitely.
If you happened to see them at trial, would you have been included in any conversations to prepare them for trial?
Repeat again, please.
If you happened to see them at trial at court, would you have been involved in any conversations to prepare them for trial?
No, no.
And you talked about your knowledge of the Wells Goodfellow neighborhood and youth in the area. Prior to your investigation in this case, were you familiar with Demoris Stepp?
No,
Were you familiar with Michael Davis?
never.
And what about Christopher Dunn?
No,
As a homicide detective, do you sometimes become familiar with repeated suspects or, well, I'll just leave it at that, with repeat suspects?
if they fall into the criteria as far as murder is concerned, yes.
Okay. And prior to the investigation of the murder of Rico Rogers, had you ever met Christopher Dunn?
No,
Had you ever heard his name?
no.
Right. And so was he a complete stranger to you?
Yes, he was.
Did you have any reason or pressure put on you to get him off the streets?
No.
Nothing further for this witness.
Thank you, Ms. Stepp.
Good afternoon, Mr. Stum. How are you today?
I'm fine, sir. How are you?
First of all, I would like to thank you for your 30 years of service with St. Louis Metropolitan Police Department.
32 years, sir.
32 years. Thank you.
You're welcome.
Now, you completed your investigation into the murder of Rico Rogers in July of 1990, correct?
That is correct.
And is it fair to say, since July of 1990, you've conducted no additional investigation of anything relating to the murder of Rico Rogers, correct?
That is correct.
And you were the primary author of the police report in this case, correct?
That is correct.
And am I correct when I say that the information that you personally obtained during the course of your investigation is reflected in your police report?
That is correct.
Now, you arrived at the scene on May 19th, 1990 at approximately 12:30, correct?
That is correct.
Now, when you arrived on the scene, Mr. Stepp and Mr. Davis were together, correct?
That is correct.
And I was a little bit unclear on your direct testimony. Did you take their statements at the scene, or did Officer Reynolds or Detective
Officer
Reynolds?
Reynolds conducted a preliminary conversation with them in order to tell me what she needed to tell me.
All right, so you didn't have any direct communications with them at the scene?
No,
You didn't talk to them until you got back to the homicide?
that is
division?
correct, sir.
Now, sir, in conducting your interviews of Mr. Stepp and Mr. Davis in the early morning hours of May 19th, 1990, you took Mr. Stepp's statement first, correct?
I believe so, yes.
And am I correct when I say that on May 19th, 1990, Mr. Stepp was a child?
A child?
Yeah, he's a child.
How do
He's
you
a
mean, sir?
14-year-old child.
Yes.
Now, I'm going to hand you, or you have with you up there, what's been marked as Movements Exhibit 21. Could you take a look at that? It's in a binder.
Is it the really big binder? Which one is it?
Yes, it's a really big binder.
Where do you want me to go?
If you could, go to Movements Exhibit 21, which is the taped statement of Demore Step.
What was that again, sir?
It's under tab 21, probably.
Tab 21. That is a big binder.
Yes, it is.
We probably should have gone double binder there.
I had that thought too.
Are you there?
Yes,
You're at Exhibit 21?
yes.
All right, perfect. Now, do you recall that your statement of Mr. Stepp, you started taking it at about 2:50 a.m., correct? You don't recall? Okay, sir, I'm going to hand you what has been marked as Movements Exhibit 46.
Recording started at 2:50.
I'll hand you that.
So-
That's your deposition transcript. It's Exhibit 46. I'll hand you that for reference if you need it. But you did find where on the interview it says it started at 2:50?
Yes, 2:50.
And sir, that interview lasted about 9 minutes. Does that sound right?
Yeah, it was short.
Does 9 minutes sound right?
Yeah, could be.
Well, let's take a look at Exhibit 46.
That's the other one.
Where do you want me to go?
All right, and let's go to page 69.
I'm there.
All right. Okay, so if you could, go with me on page 69. I'm going to go down to line 14. Are you with me?
I'm there.
All right, I'm going to read this portion of your deposition, starting at page 69, line 14. You were asked a question. So going back through this document, this is an interview with Demore Stepp, correct? Yes. Who is 14 years old? Yes. And the interview lasted for about 9 minutes. What time did it start? So do you recall that we discussed that the interview started at 2:50 a.m.? Yes. And we just saw that you stated the interview ended at 2:59 a.m. That is correct. So about a 9-minute interview, yes? Did you see
Yes,
that?
I see
Okay.
that.
So the interview, according to your deposition testimony, lasted about 9 minutes, correct?
That is correct.
Now, sir, I would like you to look at Movements Exhibit 21. And I want to go to page 5 of this tape statement. Are you there with me?
Yes.
All right, let's go to the bottom of page 5, and I'm going to read a portion of the tape statement for you, and follow along with me and tell me if I'm reading it correctly. Detective Stum, how do you, it was Christopher Dunn. Demore Stepp, I looked at his face, but you know how you see somebody and you don't see him? You know? Detective Gary Stum. Uh-huh. Did I read that accurately?
If that's what was recorded, yes, you did.
Okay. And do you have any reason to believe that this transcript of the tape statement is somehow incorrect?
No, I don't have any reason to believe that.
Now, the interview continues. Demore Stepp, you know, I thought my mind, was playing games. And I looked dead in his face. And I guess he fired. He thought I seen him, so he shot at me first. But after you're shooting or packing a gun, I guess it moved up, it missed me just by an inch. And then after the first shot, I had ducked. And I had started running. And Detective Stum, did you see Christopher Dunn prior to the shots being fired? He was shooting the gun. You see that?
Yes, I see that.
Okay, did I read that accurately?
Yes, you did.
All right, and then if you go down a couple lines, you ask Detective Stum, you ask, what did he have on? DeMaurice Stepp, he had on a white shirt and a blue baseball cap. Did I read that accurate?
Yes.
Now, am I correct when I say that in that initial tape statement, Mr. Stepp was expressing uncertainty?
I don't know how to really interpret that. I believe, based upon his statement, he probably was scared.
And in your view, when you heard that statement, there was no uncertainty in it, correct?
No.
Because in your view, it was a situation where you had a 14-year-old child, correct? You had a 14-year-old child being interviewed, correct?
Yes.
And in your mind, this is a child who's involved in gang activity, is that correct?
No, I didn't say that.
Okay, that's not an assumption you made.
No, that's not an assumption I made.
Okay. But you did say that you understood him to be scared.
Yes.
And you understood him to be scared because he was fearing potential retaliation on the streets for what he might tell you?
I don't know if it's necessarily a reflection of retaliation. I do believe it's a situation that it was a situation where he may have actually witnessed death in his face, and it could have been him. I believe it was something like that.
So you believe that what he had witnessed that evening had impacted him emotionally?
Yes.
And you believe that it continued to impact him at the time he was making his statement to you, correct?
I mean, he was reliving what he saw. He was talking about it, yeah.
And he
probably had some anxieties within it.
And he was impacted by that trauma that he had experienced that evening, correct?
Probably. I mean, you would probably have to ask him if he was experiencing that.
He's 14 years old,
Yeah.
correct?
Right.
He just nearly got shot on the street, correct?
That is correct, sir.
One of his best friends had just been shot in the head, correct?
That is correct, sir.
It's 2:50 a.m. in the morning, correct?
With this recording?
Yes, when you're
Yes,
taking
it
the
is.
statement.
Yes, it is.
Okay.
2:59, I think it was.
And as an experienced homicide detective, it's not an unfamiliar situation that you're interviewing a witness who has experienced trauma, correct?
No, it's not.
And it's not uncommon that you are interviewing a witness who's scared, correct?
No, it's not uncommon.
And it's also not uncommon for you to interview a witness who's reluctant to share information with you because they fear what the results might be for doing that, correct?
I don't know. It could be a yes, it could be a no. I mean, you're talking about a street code situation?
I'm talking about a situation where you have a witness who has information, but they maybe don't want to share it because they don't want to be a snitch. That's something you encountered regularly as a homicide detective, correct?
Not regularly, no. Not regularly.
Not regularly, but
No.
you encountered it, correct?
I've encountered it, yes.
Now, When you were being questioned on direct, you read from your police report, correct?
That is correct.
And you read the statements that Mr. Stepp made that evening from your police report, correct?
That is correct.
And when you read those statements in your police report, those statements didn't say anything about Mr. Stepp's mind playing tricks on him, did it?
No, it did.
That didn't make it into the report, correct?
No.
And it didn't say anything about him seeing them, but not really seeing them. Didn't say anything about that, correct?
No, it didn't.
Okay. Now, once that interview was concluded, you then conducted an interview of Michael Davis, correct?
That is correct.
And I'm correct when I say that Michael Davis, on May 19, 1990, was a 12-year-old child.
That is correct, sir.
Now, that interview started at 3:04 a.m. approximately, correct?
If that's what it says, yes.
And it concluded at 3:14 a.m., correct?
If that's what it says, yes.
Okay. Let's take a look at Exhibit 46, which is your deposition transcript. Okay, let's go to page 77. Let's go to line 12. And I'm going to read your deposition testimony. Question. Okay. And then if we go to the bottom of page 367, do you see where you state that the interview ended at 3:14 a.m.? Yes. Answer, yes. Question. And do you recall that on the first page, we saw the interview started at 3:04 a.m.? That is correct. So this is a 10-minute interview. Answer, yes it is. Did I read that accurate?
Yes,
Okay, so the interview lasted about 10 minutes, correct?
that is correct.
And if you could, I want you to go to tab 28, which is Movement Exhibit 28. And again, we apologize for the binder. Okay, that's Michael Davis's taped statement, correct?
Yes.
It's a transcript of it, correct?
Yes.
Okay, if you could go to page 3 of that taped statement. And I'm going to read your questions and Mr. Davis's answers. How did you know it was him? Detective Stum. How did you know it was him? Michael Davis. 'Cause I seen the way his glasses on his face, the way he wears his glasses. Detective Stum. How was his glasses? Michael Davis. Pressed against his face. Can you describe the type of glasses that he wears? Michael Davis. No, sir. Detective Stum. Do you know how they look? Michael Davis. Yes. Describe how they look. They ain't prescription glasses. They just little bitty sunglasses like. With the things that go across the ears in the back. and you're indicating, Detective Stum, and you're indicating that he has something like a wire type of, what they call that? Frame. Detective Stum, frame. Michael Davis, yes, sir. Detective Stum, okay. Did you see any type of clothing that he was wearing? Yes. What did you see? A white T-shirt. Is that all you saw? Yes. Did I read that accurately?
Yes, you did.
Now, he makes no mention of a blue hat. Is that correct?
That is correct.
Now, am I correct when I say that the tape statements of DeMar Stepp and Michael Davis, as taken in the early morning hours of May 19th, 1990, were inconsistent?
Comparing to what?
As compared to each other.
Inconsistent, whatever, I mean, we're looking at a situation, Counselor, that
But I'm happy to hear what you're about to say, but I just want you to first answer that
Okay.
question. Am I correct when I say that the statements made in the early morning hours of May 19th, 1990, the statements of Michael Davis as compared to the statement of DeMar Stepp, they were inconsistent? Am I correct?
somewhat, yes.
Because DeMar Stepp didn't say anything about any sunglasses, correct? DeMar Stepp said nothing about tiny sunglasses,
didn't.
correct?
He did.
And Michael Davis said nothing about a blue hat, correct?
I don't think so, no.
Well, if he did, it'd be in the tape statement, correct?
Repeat, sir?
If he had said something about a blue hat, it would be in his tape
Yes, sir.
statement, correct?
Yes, sir, would have.
Okay. Now, you were wanting to say something about these statements and
Disregard.
them being inconsistent. Do you?
Disregard.
Now, am I correct when I say that you didn't conduct any investigation of a potential alibi for Christopher Dunn in this case?
What alibi are you talking about?
Let me rephrase. Am I correct when I say that you conducted no investigation of a potential alibi for Christopher Dunn in this case because you received no information regarding a potential alibi?
I'm not understanding.
Okay, well, let's do it this way. Could you please take a look at Exhibit 46?
In your book?
Yep. Exhibit 46 is actually the second one. That's your deposition transcript. It's
The
not
other,
in book.
the other one.
All right, and if you go with me to page 123 of your deposition transcript, once you get there.
I'm there, go ahead.
Okay, go to page 123 at the bottom, line 25. And you're asked this question: do you recall ever investigating whether Mr. Dunn had an alibi for the night of the murder? Answer: had someone called and told me something about the possibility of his alibi, I had an obligation to investigate that also. Simply because he is afforded the same rights as a victim in this situation. I would have investigated him as well as I would have investigated the victim of the situation. Nobody gave me anything to cause me to investigate anything. I never received any type of phone call or text message or message of anything of the sort, anything that I should have investigated in this situation. Did I read that accurately?
You sure did.
All right. Thank you, Mr. Stum. Appreciate your service for the St. Louis Police Department and the city of St. Louis. Have a good day.
Thank you, Mr. Gore. Ms. Eastep, do you have further questions?
Just briefly, Judge.
Okay.
Detective Stidham, whenever you interviewed Christopher Dunn, would he provide you any additional information about the individuals he was with, or that he alleged he was with?
No, he didn't.
Okay. And if he would have provided that information, would you have tried to confirm his alibi that he provided you?
Definitely.
Okay. And then, one more question, Detective. Is it common whenever interviewing witnesses to a crime for them to focus on or see different details?
Yes.
Okay, nothing further.
Okay. Anything further, Mr. Gore? Okay, thank you for your testimony, sir. You can step down. Would people like to take a 5-minute break? Okay. We'll take a 5-minute break then. Are you doing the next witness, Mr. Crane?
Yes, Judge.
Okay.
You-
Yes.
You'll call Jeff Mancy.
Okay.
All right, this time we'd like to renew our motion in limine to exclude Mr. Mancy's opinion. Mr. Mancy is expected to testify of generally coercive prison techniques. At this point, there has really been no evidence of coercive prison techniques by any of the testimony in the last couple days. The circuit attorney has closed their case in chief, and the attorney general has already had one witness go, and it doesn't seem that evidence is suggesting that at all. As for general opinions, again, it's not the role of the attorney general's lawyers to make the link between evidence as fact and apply expert opinion. The expert is supposed to apply his own opinion to the facts. In this case, Jeffrey Mancy does not know any of the facts, so it would not be helpful to the trier of fact to hear his testimony.
Do you want to respond, Mr.? Well, I don't think I'm going to have you respond. I think I'm going to deny your motion to reconsider and stand on my written order that I already issued. Okay. So you can, where is he? Can you raise your right hand? Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Are you okay appearing on camera?
Yes, sir.
Okay. Step right up. And I'll ask you just to sit pretty close to the microphone, like 2 inches,
Yes, Your
that
Honor.
close. And wait for the entire question to be asked before answering, and if there's an objection, let me rule before answering. Okay? You may proceed.
Can you please state your name for the record?
My name is Jeff, J-E-F-F, Mancy, M-A-N-C-I.
How are you currently employed?
I'm currently retired.
Well, what did you do before that?
I worked for the Federal Bureau of Prisons through the Department of Justice for 25 and a half years.
What was your first job with the Federal Bureau of Prisons?
My first job was a correctional officer.
And just generally, what did you do as a correctional officer?
As a correctional officer, generally it was day-to-day activities, housing units, inmate accountability, responding to emergency situations and things of that nature.
In that role, did you work directly with inmates?
100%, yes.
And as a corrections officer, were you also trained to investigate crimes or violations that happened in prison?
As a correctional officer at the basic entry, yes, entry level.
What kind of training did you receive at that level?
We would receive annual training and annual refresher training on basic crime scene. I'm sorry, yes ma'am, you bet. You bet, yes ma'am. We would receive basic training annually in crime scene preservation, sketching, things of that nature.
And who would provide those trainings?
We had instructors that were instructed for the Federal Bureau of Prisons, their evidence recovery team, and they would train with them at least annually, sometimes monthly, out of Kansas City.
And did you also receive crime scene training from the FBI?
Yes.
As your career went on, were you promoted to more senior levels of corrections officer?
I was. I moved throughout the nation, and each time I moved up in an increasing role of responsibility.
Were you eventually promoted to lieutenant?
I was.
And what within the Federal Bureau of Prisons, what does a lieutenant do?
They supervise. They supervise staff, and they supervise inmates. They work directly under the warden on off shifts.
What facility did you work at when you first became a lieutenant?
I originally hired in Greenville, Illinois.
Did you also work as a lieutenant at Terre Haute, Indiana?
I did.
And just generally, while you worked as a lieutenant, what were your responsibilities as related to security and inmate investigations?
As a general, just a general lieutenant, is that your question?
Yep.
It would be staffing, daily staffing. It would be inmate discipline. It would be day-to-day running of the institution, such as feeding inmates, recreational moves, things of that nature. Inmate accountability was a huge one as well.
So did you become familiar with all of the aspects of inmate life in prison?
Boy, in 25 and a half years, quite a few of them.
And what, specifically as it relates to investigations, what did you do as a lieutenant at Greenville and Terre Haute?
In Greenville, I finally got promoted to the Special Investigative Shop, which was inmate investigations specifically, and I'd also do some staff investigations from time to time. But inmate investigations were working assaults, maybe drug passing of drugs, fights, things of that nature. And those were the investigation to see, you know, who would ship, who would stay, things of that nature. Refer to outside law enforcement as well if need be.
So you investigated both crimes and violations that occurred in prison in that role?
Correct.
And did you also work with outside law enforcement agencies?
Correct. Especially once I got to Springfield, it really expanded to federal, outside agencies, state and local.
While you worked as a lieutenant, did you train staff in how to conduct investigations?
Yes. Eventually, I got to the part on a national level. I became a national trainer, and I would train at our national get-togethers once a year, and then at our institution on a monthly basis, local staff. A monthly basis, ma'am.
And did you also continue to receive training or attend conferences to learn more about investigations?
Always continuing education, yes.
Tell me about when you went to work at the facility in Springfield.
I went there as a regular lieutenant, and then an opening came up in the special investigative shop, and I worked a homicide there with the FBI, and really clicked with the FBI and the evidence preservation side, getting ready for trial prep and all that. And from there, I was put in there permanently because of that working relationship I had with the FBI.
And how long did you work in that role?
I worked in that role for approximately 11 years.
And while you were in the special investigative unit at the Springfield facility, what were your responsibilities?
My responsibilities were to oversee the special investigative shop, which consisted of about 6 technicians, and each technician would have their own specialty. And so I'd oversee those specialties.
What kinds of offenses did you investigate while you did that?
You name it, we did it. From we investigated homicides, we investigated big drug deals, interstate drug deals, money coming through the prison on the outside. We investigated IRS tax fraud. We investigated all kinds of things. If the state brought it to us or the feds brought it to us and we were able to help them, we were an investigative arm for them.
So I think you said there that sometimes your investigations would interact with other state or federal law enforcement agencies.
That's correct, sometimes even local.
And so when you worked on those cases, did you get to assist in state investigations, federal crime investigations, and other kinds of investigations?
Correct. A lot of times the state just didn't have access to the federal side of it because of the red tape, so we'd be the investigative arm for the state and present the facts for them in their trial prep.
While you were in that role, did you exchange intelligence with those agencies, state and federal?
All the time. I think that was one of the pluses, just getting that working relationship with the state and federal. We were able to help them or they were to help us, vice versa. So yes, it was integral.
And through that intelligence, did you become familiar with the behavior of inmates in prison and how that relates to investigations at all different kinds of levels?
I did. You know, at a basic level when you first come in to at the end, you really opened your eyes working with the outside agencies because as technology grows, so do the deceptive practice of inmates. It grows as well.
During your time working for the Bureau of Prisons, about how many cases would you say that you investigated?
Internally, I would say upwards of over 500, and then outside probably another 500. So over a 25-year career could easily be in the thousands.
And during those investigations that you worked on, would you sometimes find that inmates would try to conceal information from your investigations?
Correct, yes.
And how often was that part of your job?
A majority of the time.
And did you have to monitor that type of activity?
All the time, yes.
And I think you said earlier that the techniques that inmates would use to try to conceal information would change over time.
Correct. It was like a game of whack-a-mole. Once we were able to get it in one area, they were already opening up a new avenue. So we were always chasing our tail on that. It was always forever changing.
So you'd have to continue to keep up with, you know, how they were trying to get around your monitoring.
That's correct.
And did you also find that inmates would sometimes try to influence witnesses involved in your investigations?
Yes.
And how often was that a part of your work?
It happened from time to time, inside and outside, mostly inside the correctional facility, but sometimes it reached outside the walls as well.
And did you have to monitor those types of activities?
Yes.
And did inmates, the ways that they would try to influence witnesses, did those change over time as well?
Correct.
And you would have to continue to monitor and learn about different ways that that was happening?
That's correct.
And based on this intelligence and your experience in investigations, What are some of the ways that inmates communicate with other inmates in prison as it relates to influencing witness testimony?
There's various ways. The first and foremost could be something as easy as just verbal, speaking to you, maybe on the rec yard, maybe in the chow hall, someplace that staff aren't around. Maybe I send a third party to speak to you, so I'm not being seen with you. Maybe if you're in a different prison, I communicate to you through a loved one, through visiting. Other ways, through attorney-client privilege, they communicate. So there's a lot of ways within prison that they communicate with each other.
If an inmate sends another inmate to approach a witness for them, is that normally done just for free as a favor?
That all depends. If it's done for free, more than likely they know each other and they're just doing each other a favor, but usually nothing is for free in prison.
So what kind of incentives would an inmate use to get another inmate to influence a witness?
They could either pay them commissary, they could pay them money.
I'm sorry, they can what?
They could pay them in commissary. They can pay them money through Venmo out on the street, through third parties. They could pay them in stamps.
And what is commissary?
Commissary is a store within the prison. It sells things that they can buy, such as hygiene items, snack food, and things of that nature.
And is it common in corrections for inmates to be transferred to other facilities?
In the federal system, yes, it happens all the time.
Do you know if it's common in other systems as well?
I would assume so, yes, sir.
And when inmates are transferred between multiple institutions, how can they communicate with inmates who are in other institutions?
I think the biggest way is if I'm trying to communicate to a witness and I know that there's an inmate going to that institution, I can pass word to the inmate that's being transferred. And then that way it's secure with him. So it's not in a written format, it's verbally from one man to another, and then that man transfers to the new prison and then passes on the word.
And these are situations that would come up in your work in investigations where inmates are passing messages through other inmates as they're being transferred to facilities?
In my experience, it happened a lot, yes.
When you were working on investigations, did you also monitor inmate communications with people on the outside of prison?
Yes.
And if prisoners are trying to influence witnesses who might be outside prison, what ways of communicating with them would they have?
There's different ways, especially with technology now, with the internet. One of the ways is maybe through visiting. My sister may come visit me as a scenario. I pass it on to my sister, and then my sister can reach out and touch him through Facebook. Maybe put family members on Facebook to intimidate them. There's multiple ways that you can. The other big thing too nowadays is cell phones in correctional facilities. It's an increasing problem all over the nation at any level that you look. So cell phones are another big issue to communicate, and we cannot monitor those.
Between all those different ways that inmates might communicate with potential witnesses in cases, is it possible for corrections staff to monitor those all the time?
No.
So is it possible for inmates to, and in your experience, have inmates been able to reach out and influence witnesses both inside and outside of prison without being monitored?
And I think that's the most frustrating part of the job. So the answer to your question is yes. And no matter how hard you work, there's still ways that they can go around it and beat it.
Does it make it easier for inmates to communicate and influence witnesses if they are already familiar with them?
Yes.
So, for example, if an inmate is speaking through their friends or family to reach out to other people that are from the same neighborhood, does that make it easier for them to communicate?
It does. I've noticed that through, in the state, it's a little different than in the federal system. In the state, they're from the same 100 blocks, so they know each other, and those roots run very deep within the prison and outside within the community. So yes, it could be very easy.
And when you say those roots run deep in and out of the prison, what is that information based on, your experience with the state system?
By conducting some interviews, you start talking to them and you realize that they grew up with each other out on the street. And then they find themselves within the prison with the same people they grew up with out on the street. In the federal system, that rarely happens because we have prisons all over the nation. So it's easier in state than it is in the federal for that, because we can ship you anywhere in the nation compared to the state. They don't have that luxury.
So in preparing to talk about your testimony in this case, you interviewed people who had been involved in the state correctional system?
I did. I interviewed on both sides. I interviewed prior inmates. I also interviewed prior correctional officers as well.
Understood. So I want to talk specifically about inmates who cooperate with law enforcement. In your investigations, did you ever talk to inmates as potential sources of information?
Yes, I think that's one of the biggest parts of our job is working with confidential informants and determining their reliability as you work with them.
So confidential informants are one thing, but in your experience, how do inmates treat other inmates that are known to have cooperated with law enforcement?
If we're going to talk about snitches or rats, they call them specifically, it's a rough interaction for the person telling on the other person. Rough interaction saying there could be physical assaults. They can be placed in protective custody. And if you don't know what protective custody is, that's in the special housing unit segregation for up to 23 hours a day. When they're in there, their way of life ends as they know it. They don't have access to a job, which is very important because they can earn money with their jobs. They don't have access to education. They don't have access to a lot of things that they did. Phone calls maybe once a month compared to whenever they wanted. So there's a lot of things that when you become labeled a rat or a snitch that really change your life for the worst.
In your experience, was that type of treatment of snitches limited to just the prisons you worked at, or was that all over the nation?
No, that's all over the nation, and that's just the code.
And in your experience, how do these kinds of pressures affect inmates, or affect the chance that inmates will cooperate with law enforcement?
It affected it greatly because that was their biggest fear, was having that label. Once you have that label, you'll never get rid of the label. And depending on if you're state or federal system, if you get released, that label will follow you to the street. So you could have that for the rest of your life. And then that lifestyle within the prison, that isolation of being locked up 23 to 24 hours a day was a huge fear.
In your cases that you worked on, was it common for cooperating inmates to be pressured to change their testimony by other inmates?
It was common for them to try, but we always separated them and tried to, but there was always ways they could get to them. Even in segregation, there was ways they could get to them.
In the federal system, what do you have available to you to do to try to protect inmates who were cooperating witnesses before?
For us, we can ship them to other institutions clear across the nation. We have institutions that are just for protective custody inmates where they can walk amongst each other. So we have a lot of assets to combat those things that these guys have to face on a day-to-day life.
Why would it be necessary to transport them all the way across the nation?
I think, well, for us, it was necessary for their safety, especially on big cases, so they could, come forth and tell their side of the story.
So it's safe to say you took the threats against their safety very seriously.
Always, because if we didn't and something happened, the liability was too great.
And in your experience, are those threats just empty threats, or are they real danger?
No, and I've seen them in 25 and a half years. They are real. 90% of the time, they are real and very dangerous.
All right. I have no further questions, Judge. Thank you.
Thank you, Mr. Crane. Ms. Huson?
Hello, Mr. Mancy.
How are you, ma'am?
Good, how are you?
Good, thank you.
You've never served as an expert witness before, right?
No, ma'am.
And you don't know anything about the facts of this case, right?
Of this case, no, ma'am.
The Attorney General never told you anything about the facts in this case.
That is correct.
You never did any research of the facts on this case, correct?
That is correct.
And you've never worked in a Missouri state prison or a Missouri jail, right?
That is correct.
In preparing your report, you only conducted 2 interviews, right?
That is correct.
1 inmate and 1 correctional officer.
That is correct.
Last time we spoke, about 3 weeks ago, the only thing you knew about this case was Christopher Dunn's name, right?
That is correct.
And the only reason you even knew that was because of the subpoena that I served on you, right?
Yes, ma'am.
When I took your deposition 3 weeks ago, you didn't know who DeMoore was.
No, ma'am.
You also didn't know who Michael Davis was.
No, ma'am.
You didn't know who Curtis Stewart was.
No, ma'am.
You have no understanding as to how your opinions relate to this case, right?
Correct.
No further questions, Your Honor.
Thank you, Ms. Huson. Anything further, Mr. Crane? No, Your Honor. Okay, thank you for your testimony, sir. You can step down. I'm just guessing by the look on your face, but is the next witness who used to be a judge on this court missing?
No, he was in the restroom.
Oh, okay, okay.
I can announce for the record that the state calls the Honorable Stephen Omer.
Okay. Welcome. Come right up, sir. Good afternoon. Can you raise your right hand? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Oh, are you okay appearing on camera for the media?
Prefer not to, but whatever. It's your call.
Okay. I think I'll take that as a yes then. You may proceed.
Thank you, Judge. Good afternoon, Judge Omer. How are you?
Fine.
Thank you for being here. This microphone is not the greatest. You may need to pull it pretty close to you or perhaps lean forward. I'm sure someone will let you know if we can't hear you. Will you please state your name for the record?
Stephen Omer.
Are you currently retired?
I am.
Recently?
About a month ago.
All right. And what position did you retire from?
I was a circuit judge here in the city.
All right. And it's all right if I refer to you as Judge Omer?
Whatever you prefer.
All right. I feel
Call
kind
me-
of disrespectful.
People call me a lot of names. So I don't care.
Once a judge, always a judge to me. Judge, could you please summarize, well, prior to becoming a judge, when did you take the bench?
I took the bench in 1994.
And prior to that, how were you employed?
I was employed in the circuit attorney's office.
How long were you in the circuit attorney's office?
I started in '79, and I left when I took the bench. But I went in private practice in between for a while. So I think I was there about 11 years.
Okay, so 11 years with a short break in the middle?
Correct.
All
About
right.
4 years break.
Okay. And whenever you were at the circuit attorney's office, at least in the latter part of your tenure there, did you work in a specific unit or trial team?
I was on the trial staff. You worked your way through. I was on the trial staff, and at the end, I was the chief warrant officer.
Okay, and as the chief warrant officer, are you prosecuting cases at that point, taking cases to trial?
We still had a caseload, yes, I did.
Okay. So at this time, I'm focusing particularly on 1990, were there specialized units within the circuit attorney's office, or was it just felony trial?
We had teams, felony teams. There really weren't specialized units. We handled pretty much everything on these different teams that we had. And there may have been a sex crimes unit that was just kind of beginning. But other than that, but even there, all of us handled sex crime cases as well.
Okay. And as a trial lawyer, prior to taking the bench, approximately how many cases did you try to a jury?
Oh, I'd say in the neighborhood of 100
All right.
in my civil practice and my prosecution. So somewhere in that area, maybe a little less, but around there.
Okay. And I assume that over the years, some of those cases were homicide cases?
Yeah, I handled the gamut, homicides, robberies, A, B felonies, C felonies, D felonies, misdemeanors. We handled pretty much everything.
Okay. And as an assistant circuit attorney in any case that you're prosecuting, do you have to make credibility determinations when issuing a case?
Well, always. The police have the initial interaction, but then we interview the witnesses and present witnesses. So absolutely, we make those determinations.
And what was the process for law enforcement to present a case for charges to the circuit attorney's office?
They would come to the warrant office and have the witnesses have a police report and present that to the attorney for the attorney to determine whether or not to issue a case and what kind of case to issue, or refuse it if there wasn't sufficient evidence, or take it under advisement because it, maybe more had to be done, and direct the police to do further investigation.
Okay, and what was the purpose of law enforcement bringing witnesses to the warrant app?
We wanted to be sure that we had a viable case. We wanted to, the police report has that information, but ultimately witnesses are what make or break a case, and we wanted to be confident that if we were issuing a case, we could walk immediately down the hall and present the case to a jury.
Okay. After the initial, if you do choose to issue charges in a case, after the initial filing of charges, do you, are there kind of tests along the way to allow you to continue to assure that you have a case strong enough to take to a jury?
Well, you keep in touch with witnesses through your investigator, and obviously, the defense, gets involved, and you're presenting in a homicide or felonies. The case goes to a grand jury, and witnesses are presented there, or it's a preliminary hearing. You might have witnesses there, depending on the type of case. You certainly have police. You may have lay witnesses too. And then whatever discovery process takes place with the defense, and then ongoing contact with witnesses by your investigator and by yourself, ultimately leading to the trial itself.
Okay, I'm going to break that down just a little bit. So you talked about grand jury. Is that an opportunity to test the strength of a case?
Oh, I mean, at that point, you're pretty comfortable that, you issued the case. I mean, we tried to, in the office, that whoever the attorney was who issued that case, that was their case. So in that sense of vertical prosecution, it didn't always work. There was always an attorney assigned to the grand jury. But it gave you another opportunity. So you were fairly comfortable, but you want to be sure things don't change. And it's another chance to present a witness or the evidence to an impartial body, and to make sure you have what you think you have.
Okay. And sometimes, in your experience at the circuit attorney's office, would witnesses sometimes fail to appear at the first time that they're being called to testify?
Oh, certainly that could happen.
Okay. And in your experience, would witnesses also at that time express reluctance to cooperate?
Certainly could happen.
Okay. And is that something that bringing them to the grand jury allows you to identify?
Oh, I don't know if that so much. Your investigator would have contact with the witnesses, and that would come to light usually before the grand jury.
Okay, so even
but
before
it
that.
could, that could as well at that time.
Okay. And then after grand jury, as you're working up to trial, were there practices within the circuit attorney's office where you kind of staff your case or wreck your case with a supervisor?
Well, we were on teams, and the team leader, there was the team leader, and then you might have had 4 attorneys under that, 3 or 4, I don't remember exactly. And so and then you had your cases assigned to you, however many they were, depended on the seriousness and where you were at. But I mean, you could have anywhere from 30 to 100 cases, and so you would wreck that. You would do a summary and make a recommendation of the case to your to the team leader, who then would have a meeting and just determine what the appropriate recommendation would be.
Okay, and that's based on the strength of the case or the evidence in the case?
Yeah, strength of the case, evidence involved in the case, the history of a defendant, just, you know, the whole gamut of what you were aware of to fully evaluate that case and then have it looked at by more experienced lawyers as well.
Okay. And I'm going to direct your attention to a case that you tried to a jury back in 1991. You were the trial attorney in the prosecution of Christopher Dunn for the murder of Rico Rogers. Is that correct?
That's correct.
Okay. And you talked about this a little bit, but in 1990 to 1991, that time period, did the circuit attorney's office have a vertical prosecution policy?
Yeah, we did.
Okay, or at least tried to?
We did. It's never was exact because conflicts could happen and so forth. But yeah, no, that was the general idea. Yes.
Okay. And so I'm going to show you what's been admitted as Respondent's Exhibit P. I'll provide you a copy of this. I can approach Judge Shea.
You may.
I think we can probably move this binder out of your way.
It's not bothering me.
And use the top of it, maybe.
That's all right.
Mr. Gore has apologized about the size of the binder, so.
But I just slide that over. There you go. All right, and is that document that I just handed you a warrant application?
Yes, this is what the police would bring to the warrant office when they were presenting a case. It would get logged in the book and then given to the individual lawyer who would then take the officer, or the officer would come back to the particular interview room and the process would begin.
Okay, and Judge, even if you don't remember specifically, if the reports indicate that the detective brought DeMorris Stepp, an eyewitness in this case, to the warrant application, would you have talked to him?
Talk to,
The witness.
oh, all the time, absolutely. That
Okay.
we expected witnesses to be there. We would not entertain a case without a witness.
Okay, so it was a requirement that a witness be brought
That
for you?
was definitely.
Okay, and what would, in a case where there's an eyewitness identification of a suspect, what would be the purpose of you speaking with that witness at the warrant app?
Well, you know, you can read a police report and you know, and see what, you know, was there and said, but you want to talk to the witness to be sure that it's accurate and what the witness has to say specifically, and make sure that it all aligns, and that and explain to the witness the process and whether we go forward or not. I mean, that's, you know, you talk to any witness, you know, and even if you don't have enough evidence, you know, you still want to talk to the witnesses and see, and then explain to them that we can't go forward for whatever reason. So yes, that was, you know, that was the office policy always was, because, you know, you can't just rely on what's been put down on paper.
Okay, and based on that document in front of you and that warrant application, did you make the decision to issue charges in that case?
Well, apparently my signature's on there. It looks like mine. I don't, you know, have any. This is, you know, whenever, what, 1990? I don't have any independent recollection, but I'm sure that was me.
All right, and then when would have been the next time for you to interact with the eyewitnesses in the case? Would it be that grand jury time we were
It
talking
would be
about?
at the grand jury.
All
Yeah.
right.
We would have set the case on the grand jury docket at that time. And so, if I handled it, I'm not sure, but presumably I would have. That would have been the next time, though.
All right, and I'll show you now what's been previously admitted as respondent exhibit Q and ask you if you recognize that.
I do.
And what's that, Judge?
This is an evaluation sheet that the attorneys would fill out, whether it was at a preliminary hearing or at the grand jury after the warrant was issued, in order that whatever attorney was handling the particular case at that juncture, the attorney would make notes on the evaluation, either for themselves or for another attorney who may handle the case.
Okay, and so looking at that sheet, does that indicate to you that Demoris Stepp and Michael Davis both testified at the grand jury?
Yep, that's what it would say.
And does that grand jury summary include an opportunity for, and does that appear to be your handwriting?
It does appear to be my handwriting.
All right. And so would that also be an opportunity, and I think you touched on this, but for you to indicate any witness evaluation or know any potential issues moving forward?
Yeah, I think would be what it's, yeah.
And what did you indicate about those two witnesses at grand jury?
That both Davis and Stepp, good, which basically means they were solid. And it does indicate Michael Davis moving to California. And I don't remember exactly about that, but just an indication of good witnesses.
Okay. And then you talked about that kind of staffing a case or meeting with your supervisors or more experienced attorneys in the office just to get a sense of the case. I refer to that as a Roger sheet. You know what I'm talking about?
Yeah, that's what it became known as,
Okay.
because she was the chief trial attorney, so she headed the evaluation team, and so those sheets, evaluation sheets, became known as Roger sheets. Yes.
All right, and I'm going to show you what's been previously admitted as Respondent's Exhibit R. And ask if you recognize that to be the Roger sheet or the kind of case prep sheet associated with this case.
Yeah, looks like it, yes. Yes.
All right, and I think you talked about this earlier, but is this where you would have the opportunity to talk about case strengths and weaknesses?
Yeah, you're doing an evaluation, try to give history for the team. You generally would talk with your team leader in anticipation of their rec meeting. So you would, fill it out with that in mind and with your recommendation on the case as well. So you would be trying to summarize it as thoroughly as possible so that a reasoned, informed, and viable decision can be made.
Okay. And then, Judge, what was your practice, at least back in 1990, as far as meeting with witnesses prior to them testifying at a jury trial?
So you mean at the time of trial?
Like, would you meet, let me ask a different question. Was it common practice for you to meet with your witnesses to prepare them for testifying in court?
I generally didn't meet with them, because you're handling dockets and a lot of cases. So I only met with them when we had a particular hearing. And because, my investigator would keep in touch with them, and that was the key to make sure that they were on board, they knew what was going on. But I did not generally meet with them unless there was a reason, a deposition by the defense, motion in front of the court, or the trial itself. So, generally I did not really have contact, I relied on my investigator who would advise me if there were problems. If there were a problem, then certainly you may weigh in however was appropriate.
All right. And once you get to trial as a prosecutor, are you, is it common for you to be taking notes, at least during parts of the trial, as facts or evidence comes out that you think will be important to note in closing?
Well, we always had a legal pad, and sure, you're kind of taking notes as you're going along, because you were alone. You didn't have a second seat. In my years on the bench, I've been involved with a lot of cases, and you got a multitude of lawyers. Now, we didn't have that, frankly. We tried our case. We had an investigator who would be sitting behind and could do something for you, but it was you. So I had a legal pad, and certainly you would make notes as you went along. That to jog your memory if there's something you wanted to, touch on or something that needed to be addressed. So,
Okay.
yes.
And Judge Elmer, we've been talking about the case, the prosecution of Christopher Dunn. In this case, did you ever threaten any witnesses to testify?
No.
All right. Did you ever emotionally manipulate any witnesses to testify?
No.
Was there ever a time where a concern was brought to you about witnesses being reluctant to testify?
I have no memory of that in this case. I mean, there's certainly been instances, but I never had any sense of that here.
Okay. And would you have ever shown a witness pictures of a deceased victim to try and coerce them into testifying?
Well, I never would coerce a witness to testify, never did. So I don't remember ever showing photographs to a witness other than if it was necessary, and that, they were going to have to identify something in terms of their testimony, and be able to identify the photograph. But no, that's not, I wouldn't do that.
All right. I'm going to show you now what's been admitted as a respondent's exhibit S. And it's a couple pages. And I'll present to you that the backs are blank. They're just scanned in as they were in the file. But do these appear to be your trial notes from the prosecution of Christopher Dunn? Or at least part of them?
Well, I would say they do appear to be my handwriting, and
Let me ask you
the
this.
only way I can identify them from this is it's got some of the names are in there, so I'm assuming that's correct. I don't know.
You anticipated my next question. Do you see on there where it says DeMorris Stepp?
Yeah,
And what did you indicate about his trial testimony?
have on there, very good.
Okay, and I'll direct you to the bottom of the next page.
Yeah,
And what did you indicate about DeMorris Stepp's testimony?
did not change story.
Okay. And are those things that you would have been taking note of to point out to a jury potentially?
Well, I'm assuming that I probably did those during cross-examination, my guess, because during direct, I would not be writing down any information. I would be directing the witness. So I'm assuming during cross-examination, that's when I would make these kind of notes for me to whether in redirect to ask the witness for clarification or for closing argument.
Okay. And then the last thing I'm going to show you, if I can find it, is what's been admitted as Respondent's Exhibit T. And direct you just to the
have water, do you? Like she-
No, but we'll get you one.
Get a cup of
Can you
water.
get my water?
I would appreciate that.
Sure.
Looks like my friends on the other side here have one for you, Judge.
Oh,
Thank you.
Okay. Never mind, Mike.
Okay. I appreciate it. Thank you. Okay. Exhibit T.
And what does that appear to be?
Well, there's two documents here.
And I'll focus your attention to the one that you can see in full at the bottom. I think it's titled,
Well, that is like an internal card we used to keep in this big computer, I don't know what we call it, Big Mona or something. It was a big revolving. And internally within the office, we kept jury trial information cards on cases, so that each attorney, after a trial was over, win, lose, or draw, you would fill out these cards with basic information, and then they would go into this machine. And so any attorney or investigator, you could access that and look at pull up the history, and then go look at the file if you needed to, or maybe on a co-defendant kind of case or something, some connection, so that you could cross-reference information.
okay. And were the trial attorneys responsible for providing the information for those sheets or
Yes.
cards? Okay.
Yeah, that's all in my handwriting. So
Okay.
yes, that was our duty.
And what was the, at least according to what you put on this information sheet, what was the decisive factor in verdict?
I have testimony of kids was very strong.
And whenever asked on that card, would you still issue charge? What did you indicate?
Yes.
Okay. All right, I'm done with that one. You can put it down. Thanks. In regards to the eyewitness Demorest step, and it came out in the trial transcript, but looking at the trial transcript, there was some sort of deal made with Demorest step on a pending case for him being a cooperative witness. Does that sound familiar to you?
Yeah, I mean, from looking at stuff, yeah.
Okay. And is that unusual practice in the city of St. Louis to have testimonial agreements?
No, not unusual.
And the attorney for Christopher Dunn in this case was Janice Good. Did you have a good working relationship with Miss Good?
We tried a lot of cases together. She was in the public defender's office, and we tried a lot of cases, and we were very respectful of each other, and very professional, and we just tried the case, and won some, lost some, but she was just very professional, and easy to get along with, and we just both tried to do our job and our duty, and we just didn't play games with each other. We just got down to what needed to get done, and then whatever the issues were, and handled them in the court.
Okay. And so would you have ever made any kind of agreement or promises with a witness that you didn't tell Miss Good about?
I would have never done that and not told whomever about. Certainly. I mean, that's, it's an obligation as a prosecutor.
All right. And you took that obligation very seriously?
Absolutely.
And how would you likely have told Miss Good about that prior to trial?
I don't remember exactly. I mean, you make recommendations, and you have ongoing discussions. At that time, the public defender's office was in the basement of the Immunity Courts building. We were on the 3rd floor. Grand jury was on the 2nd floor. And there was this interaction between offices and the attorneys on a regular daily basis. so it was kind of, informal in that way, so, I don't remember exactly, I'm sure I told her face to face, but I'm sure could have given her a note, or I just don't really remember how I did it.
And let's talk about the agreement. You had the opportunity to look at the trial transcript and the plea transcript of DeMaurice Stepp in this case, is that right?
Yeah, I kind of glanced at it, I did.
Okay, and so DeMaurice Stepp was charged with first-degree robbery, armed criminal action, first-degree tampering, and UUW for carrying concealed. Is it, based on what you reviewed, is it your memory that the offer was to drop the armed criminal action?
That's what it appeared to be, yeah.
Okay, and in terms of sentencing, what does that mean?
Well, armed criminal action carries a minimum 3-year imprisonment. No probation, no parole. So the other charges carry whatever the sentence, but there's no minimum amount at that time. So things have changed, but at that time. So what that meant was that there wasn't a minimum, 3-year sentence. It was the sentence with the others that then, probation was possible, or even, parole earlier is possible because you don't have that minimum 3-year sentence.
Okay.
So that is taken off the table.
All right, and other than dropping the armed criminal action so that he was potentially eligible for probation, was any additional promise made to recommend probation by the state?
No, not, that, the office, the policy of the office always was to take no position on probation. That was up to the court. And we made, our recommendation based upon, our evaluation. And, then any issue of probation or in connection with that sentence is up to the court.
And
so we never took a stance on that.
Okay, and in this case with DeMaurice Stepp, did the state recommend 15 years?
That's my recollection looking at that. It was a 15-year sentence on the robbery 1.
Okay.
Which is a minimum 10 to and up to 30 or life, but the recommendation was 15, yes, concurrent with the other charges, and dropping the ACA for the minimum mandatory 3-year sentence.
All right, and anything about that agreement surprising or unusual to you for a 15-year-old?
No, that, you're looking at cases, and, I don't know when that would have come about, but, you're trying to, and you negotiate, you talk back and forth, you evaluate, and, you're just trying to look at the total picture and trying to figure out what's fair, and go from there. So, I think that's not unusual at all.
And was that offer given to DeMaurice Stepp to overcome his reluctance to cooperate?
No. There was nothing along those lines. His statement, it never changed from the beginning to me, or in the police report. It never changed from day one. And then, at the police, the warrant office, the grand jury, and then leading up to trial. And I don't remember, somewhere in the interim is when I think that case happened, didn't it? I don't even remember.
You mean the case that he picked up?
Yeah, the robbery case that he pled, that was after this incident, I believe.
I think the records indicate it was about 6 months after.
Okay. So, I mean, that was later. And, you know, I don't remember exactly how, but there's no memory that I have of that indication, you know, that had, in order for him to testify, you know, we had to make some kind of deal, because he was always cooperative and it didn't change. But, and I don't remember the discussion about, and I don't think that was Jan Good. I don't know who was the attorney on that case. But, you know, in the give and take there, you're just trying to, you know, trying to be fair and okay, we can do this. But it's still up to the judge. I can't promise anything along those lines. Never could.
All right. And Judge Elmer, did you treat the murder prosecution of Christopher Dunn the same as any other defendant?
Yeah, I mean.
Did you have any prior knowledge of him? Prior,
Christopher Dunn?
correct.
No, no.
Did you receive any pressure from the police to prosecute the case?
No, no. I mean, they always want to, they want us to prosecute, but no, there was no, this was the same as we always would do.
All right, just kind of a same as any other case, just following the evidence, presenting the evidence?
That's our duty to do, you know, what's right and fair. We never wanted to proceed on anything if we could not prove a case.
All
and
right.
it's ultimately it's up to a jury.
All right, and so
Not
that's what you
us.
did in this case?
What's that?
That's what you did in this case?
Yeah, that's what I did.
All right, nothing further.
Thank you, Ms. Eastep. Mr. Shaw?
We have no questions for Judge Elmer.
Okay. Thank you, Judge Elmer, for your testimony.
Thank you.
Good to see you. Have a good day.
It's always good to see you. You want these back?
I'll
You'll get them? I'm excused?
You, sir?
All right. I recommend retirement.
Okay, good. I got a ways to go.
It'll happen before you know it.
Do you have further witnesses, Ms. Eastep?
No, Judge, no further witnesses for the attorney general request.
Okay. So are we moving to closing arguments now, or do you guys maybe take a break and then come back and do those? What's that? Yeah, we can do that. At this time, we're gonna take a little break until 4:15, and then we're gonna come back for closing arguments. Each side is gonna have 30 minutes for their closing arguments, so we'll begin at 4:15. Okay. Sure. Okay, we'll go back on the record. So we're going to be doing closing arguments now, and each side is afforded 30 minutes. So Judge Shaw is going to go first for 20 minutes, I think you said. And then, is that correct?
That is correct, Your Honor, but Mr. Gore will begin.
Oh, Mr. Gore, I apologize. Mr. Gore will go for 20 minutes, and then Ms. Estep will have her full 30, and then Mr. Gore will have 10 minutes for rebuttal. And I'll ask that no one gets up and leaves or moves about or anything while they're arguing. In between each arguer, if you need to leave, that will be okay, but just stay put where you are while they are arguing, okay? Mr. Gore, yes, sir. Okay, we're going to be fairly informal about that, and I'll give you guys as much time as you need, actually, as long as we're not here till 8 o'clock to say what you want to say, okay?
Nothing like that, Your Honor.
Okay. You may proceed.
All right. May it please the court, counsel. Judge, 34 years ago, almost to the day, Mr. Dunn was convicted based on the alleged eyewitness testimony of 2 children. It was a eyewitness identification that was made under circumstances that made it highly probable that there was a risk of misidentification. It was nighttime. The ID occurred in the midst of the children running for their lives. And the shooting was conducted by someone who clearly had designs on not being identified and had staged the entire murder to happen that way. What this hearing has been about is it is not a retrial of the original case. What our purpose here today is to show by clear and convincing evidence that there remains no credible evidence to support Mr. Dunn's conviction. And I think it's undisputed, and it's always been undisputed, that the only evidence supporting Mr. Dunn's conviction was the testimony of 14-year-old Michael Stepp and 14-year-old Damaris Stepp and 12-year-old Michael Davis. And they have since recanted that testimony. And Your Honor, to be clear, our motion that we filed and you've reviewed, nowhere in that motion do we ever attack the investigation, the manner of the investigation, or the manner of the prosecution. Our motion is premised on the fact that the testimony that supports the conviction is no longer credible and cannot support a conviction. And we've presented in the last 2 days ample evidence to show that. We take a look at Damaris Stepp. He has recanted on multiple times, which is why we have to date his recantations. 2018. But there is no dispute, is there, that you lied at Mr. Dunn's trial. Is that right? Correct. Michael Davis. We have the 2015 affidavit recantation. I couldn't see. It was too dark to see anything that night on a lot. We have the Michael Davis 2015 recantation in his interview, which was played here for the court. So I went under oath and I lied. I said he did it. I'd never seen him do it. You know what I'm saying? And we listened to that testimony played audibly, and I submit to Your Honor that his manner, and the manner in which he presented that testimony in that interview was extremely credible in terms of his recantation of his testimony. He said that his testimony was fabricated, and he explained that he was simply following the lead of the older, only by 2 years, but the older DeMorris, who was the first one to falsely identify Christopher Dunn as the assailant who committed the murder of Rico Rogers. Now, we have the recantations, so the question becomes, are those recantations credible? And we submit to you that they are. If we look at the very outset, those taped interviews, right from the very outset, the two children were expressing uncertainty as to their identifications. DeMorris, you see somebody, but you don't see him. I thought my mind was playing games. That's the very first night. Expressions of uncertainty. Their testimony from that very first night was inconsistent. DeMorris originally says that he believed he saw the assailant come from the west side of 5609, and he subsequently changed that to he saw the assailant come from between the gangway, which is between 5607 and 5609. And we see here that in the original question, Detective Stum misstated it as the 5700 block rather than the 5600 block. But right away, the inconsistencies began. Here we have him at slide 8 saying that the assailant was hiding around the corner, which is very inconsistent because he's saying he's hiding, so how can he identify him? Then at trial, we have DeMorris testifying that he saw the assailant about 3 minutes before he ever fired, but didn't react, chose not to react. And that's a statement that doesn't arise until trial, and he places it in the gangway. And interestingly, DeMorris is the only witness out of all the statements that have been made that places the assailant, the murderer, in the gangway between 5607 and 5609. Here he is in 2005, recanted again. It was too dark. I couldn't see anything at night. We go to slide 11. Here he is in an interview with the Attorney General's office, an interview that they put forward as a recantation of the recantation. But even in that interview, he's recanting his original testimony. I didn't actually see Dunn with the gun. That it wasn't Dunn who pulled the trigger that night. We go to slide 12. The 2018 habeas hearing testimony. Did you see the person firing the shots? No. So was that because it was dark? It was dark. Now the interesting thing about the May 2018 testimony is that let me see if I can get this straight. It's a recantation of the recantation of the recantation, right? So he's back and he's saying, all those things I said, they said that I said when I rejected the recantation, I never said those things. More from 2018. So that would have been a lie, isn't that right? Yes, it would have been. Now, what other corroboration do we have of the recantations, other than the improbability of the identification to begin with under the circumstances that we understand existed in terms of lighting, in terms of the fear and trauma that the children were experiencing? We've got corroboration from Curtis Stewart. And this is back in 1991. Curtis Stewart, who was confined with DeMaurice Stepp, which DeMaurice Stepp has acknowledged, yes, I was confined with Curtis Stewart, overheard him saying that he didn't really know who had killed Rico, and that all he cared about was that he was getting a deal. That's Curtis Stewart overhearing that in 1991. He did an affidavit in 1994, and he testified in 2018 at the habeas hearing. Then, of course, we have the ruling by Judge Hickel, where Judge Hickel simply rejects DeMaurice Stepp's testimony in total. He's a completely unreliable witness. I just reject out of hand everything he says. And that's our position, Your Honor. You look at DeMaurice Stepp, and he has obliterated himself as a witness. His testimony, whatever he says about this matter, should no longer exist. But I would also submit to you that if you're going to make an analysis of which of his statements are most credible, looking at the surrounding evidence, the recantation is his most credible position he's taken. But we don't at all object to Judge Hickel's position, which is his testimony should not be considered at all. What is the other corroboration of the credibility of the recantations? You have the fact that at the very outset there's this inexplicable inconsistency between the children. One saw him wearing tiny sunglasses, which, as Dr. Franklin pointed out, was really the sole basis for him identifying Christopher Dunn. He identified him based on his statements in that taped statement by the sunglasses. And then you have the older child, DeMaurice Stepp, seeing no sunglasses, saying nothing about sunglasses, and identifying him as wearing a blue cap. Now, the sunglass testimony is improbable because we notice occurred at 12 o'clock midnight. 12 o'clock midnight. And you're trying to shoot somebody from I think the closest anybody places the shooter is 12 to 15 feet, and you're wearing sunglasses. Makes no sense. And that was at the outset. Now, the fact that the matter proceeded to trial and 12 jurors here in the city of St. Louis found beyond a reasonable doubt that the testimony was credible and they convicted Mr. Dunn, that happened. But those jurors did not have the information that's before us today of these multiple credible recantations of that testimony. We've heard Davis provide all of the reasons why he testified the way he did, and we heard his very credible interview statements regarding that. And are those, that 2015 recantation, is it credible? Well, it is, because if you go back and you look at the very early testimony, you see that in his taped interview, he says, you know, how long did you know Christopher Dunn? I knew him for about a month. Had you seen him any time prior to this incident happening? Yes. Knew him for about a month. At trial, he testifies. And do you know Christopher Dunn? Yes, sir. How do you know him? As a friend. Right away, you've got the inconsistencies. And you'll recall in Mr. Davis's 2015 interview, he's surprised when they tell him, you described him as a friend. He goes, really? Are you sure? Take a look. He goes, I'm not sure I ever would have described him as a friend. Now if we go to slide 19, we see more testimony from the 2015 interview. And this to me is just a very credible statement about what he did. So I went under oath and I lied. I said he did it. I'd never seen him do it. You know what I'm saying? The shot was like a sniper. We never seen the shooter. And it's interesting because that term sniper comes up a couple times, because you'll recall that's also how Eugene Wilson described it. Eugene Wilson even had a theory that somebody might have been shooting from an apartment window because it was dark and nobody could tell where the shots were coming from other than west. And if we look at slide 20, Mr. Davis provides very credible explanation about why he made the statements and why he recounted all those years later. He said that as an adult, he grew to realize that you can't just say that, you know. What I'm saying, somebody did something and you didn't know, and you take their whole life away. You know what I'm saying? Because it is hell in prison. You know what I'm saying? That's a very credible explanation of a grown man realizing the impact of something that he did as a child. So, Your Honor, Stepp and Davis are proven liars. That places us in the same place the judge found himself in the Amrine v. Roper case, where the judge said, in these peculiar circumstances, the state should get no benefit of the original judgment because it is based solely on the testimony of liars. Eugene Wilson, an extremely credible witness who came in and gave what I consider to be the most credible eyewitness testimony about what it looked like out there. And he also used the term sniper. It was like a sniper. We couldn't see where the shooting was coming from. And he places himself about 15 feet from the porch. And the interesting thing about Eugene Wilson is he also takes us inside the minds of that 12 and that 14-year-old and explains to us why they would do something like they did. First of all, they're 12 and 14, so who knows why they're doing what they did. But he says, you know, they considered themselves bloods. More likely, as Detective Stum explained, they're perpetrators. But they considered themselves bloods. And Mr. Dunn came around that evening visiting with his good friend, Eugene Wilson, and happened to have on a Cubs hat that was blue. And so they considered him a Crip. Or there was a discussion that he was a Crip. And Mr. Wilson speculates that that's why they identified him falsely. And he was there for the whole thing. And Your Honor, if you look at the evidence that's been submitted by the Attorney General during this hearing, what they are essentially doing is inviting this court to adopt the same reasoning as that 14 and that 12-year-old. We're bloods. Rico Rogers was wearing a red hat. Christopher Dunn was here a few hours ago wearing a blue hat. My friend is dead. Somebody needs to be held responsible. Mr. Dunn's a Crip. Let's say it's him. Let's go with that. That was DeMaurice Stepp's reasoning, and he passed that on to Michael Davis, and we find ourselves here today. And everything I've heard from the Attorney General is let's stay with that. Let's ignore the recantations, and let's stay with that reasoning of a 12 and a 14-year-old. Reasoning that they now reject as men. We heard the testimony from Dr. Franklin, and she spoke in detail about the science supporting the improbability of the ID that DeMaurice Stepp and Michael Davis alleged that they made. And that comports perfectly with what we now know. They didn't make the ID. It was all fabricated. Now, we just heard the testimony of Judge Omer. And like I said, we're not at all attacking the manner in which the prosecution was conducted. All Judge Omer's testimony establishes is that these children were convincing in their lies, in their fabrications. And why were they convincing? Well, we heard that from Detective Stum. You know, he construed their inconsistencies, their uncertainty, their at times throwing out facts that defied all logic. He construed that as something else. He construed that as the impact of a trauma, fear, being scared. What he didn't realize, because they were effective liars.
That's your first 20 minutes, but you can proceed.
What he didn't realize, Your Honor, is that it was a completely fabricated story. Now, if we go to the next slide, we have the testimony of Scott Roeder. And that testimony just provides some visualization for the court in terms of what things were like that night. And you've got someone whose whole intent in being out at 12 o'clock at night, planning to commit a homicide, their whole point is not to be seen. And that's what he's depicting here. As DeMaurice Stepp said that evening when he was first interviewed, this assailant came out from around 5609, the house next door, and started shooting, making an ID nearly impossible. If DeMaurice Stepp had really seen all he said that he saw, he wouldn't be here today. He wouldn't have survived that shooting. He would have been staring someone who was intent on killing him right in the face for 3 minutes. It makes no sense. And then, Your Honor, we have the testimony of Nicole Bailey, which was incredibly credible. She places herself on the phone with Christopher Dunn during a time when cell phones were not prevalent and he was at home on his landline. That testimony is corroborated by the testimony of Mr. Dunn's mother and his sister. And we know, Your Honor, from the testimony of Detective Stum, if we go to slide 29, we know that that alibi was never thoroughly investigated. Had it been investigated thoroughly, had it been submitted at trial, we might not find ourselves here today. At slide 30, we have the testimony of Christopher Dunn from the habeas hearing, where he points out that he provided the alibi testimony to his attorney, but it was never presented. And the final analysis, Your Honor, if we go to slide 32, we have met the standard as laid out in the statute. Our case parallels Amrine almost exactly. In light of the resulting lack of any remaining evidence of Amrine's guilt from the first trial, Amrine has already met the clear and convincing evidence standard. For our confidence in the outcome of the first trial is sufficiently undermined by the recantation of all of the key witnesses against him. And that's what we have here, Your Honor. There is no evidence that remains. The recantations are credible, and we have met our standard of clear and convincing evidence of actual innocence, because there remains no evidence upon which a reasonable jury could return a verdict of guilty. And in fact, Your Honor, in this case, there simply remains no evidence at all. Thank you.
Thank you, Mr. Gore. You'll have about 6 minutes on rebuttal, give or take. You're fine. You can move the podium over if you need to.
May it please the court,
You may proceed.
counsel. An innocent man's best defense is the truth. The evidence and information that has been presented to this court and that is available to this court to review post-hearing is written with lies. And those lies come from Christopher Dunn. I'd like to start first by talking about the alibi evidence that has been presented to this court. Whenever Christopher Dunn, the first time that he spoke to anyone about his whereabouts on the night and early morning of May 18th, May 19th, 1990, he told law enforcement that he left his house at 10 p.m. He rode around the city with his friend Wilford Rickman. He said that he was at, then around midnight, after he was with Wilford Rickman for a couple of hours, around midnight, he went to the residence of a friend named Terry's house and spent the night, returning to his house at approximately 7 a.m. the next morning. This statement was given to the police before Christopher Dunn had the opportunity to talk to his family. The first time that his mother, Martha Dunn, spoke to the police, she told the police that at the time they had arrived at her house, which we heard from Detective Stum today, that it was sometime after 2 o'clock in the morning, that at the time they arrived there, Christopher Dunn had been home about an hour and a half prior, and he was with two other individuals and left. The second time that the police talked to Miss Dunn, she said that he had not entered the premises since they had been to her house before, but upon learning what he was arrested in, the clothing that he was arrested in, she said, well, he must have come home because he's in different clothing than he was the last time I saw him. She said, the last time I saw him, he was in a white t-shirt, white shorts, and a blue baseball cap. The third time that the police spoke to Martha Dunn, she stated that Christopher Dunn left her residence between 11 and 11:30 during the evening of May 18th, 1990, and that he came home around 2 a.m., and that at that time, he entered the family room, started taking off his clothes, and went to sleep on the couch. We heard testimony read into the record from Chris Dunn's family a couple of years later at his PCR hearing. This story completely changed. Now, Chris Dunn is purporting to have been home all night. But what we also know, and what we heard today, is that whenever police arrived to Martha Dunn's home, where Chris Dunn is purporting to have been on the night and the murder of Rico Rogers, and when police got there, Ms. Dunn let them into their home to look for Christopher Dunn. And they went to his room, and he was not there. They did not see him in the home. And that is because the purported alibi of Christopher Dunn being home all night is a lie. We also heard alibi evidence, well, from this PCR hearing. And this is in the record, and his attorney, the trial attorney, Janice Good, was asked why she did not present certain alibi evidence. And she answered part of it was that it was a very weak alibi, if not a bad one. And she testified that she then had a conversation right before trial with Angela and Wilford Rickman, who had been present during the interview with Mrs. Dunn and all the other people. And the record will give context to that it was the rest of the family members. And they indicated, in fact, Christopher had left the house at some point and that he was actually gone at the time of the shooting. Nicole Bailey is another piece of the purported alibi today of Christopher Dunn. We heard today that Nicole Bailey, then Nicole Williams, at some point, I think she testified today that at some point she spoke to Emily Blood, which the record will show was the PCR attorney representing Christopher Dunn. And she testified, and I think I showed her that testimony on cross-examination, that she came down and spoke to Ms. Blood and told her everything that she was testifying to at the habeas hearing, and agreed with me that it was everything she was testifying to today. She knew that her friend, Christopher Dunn, had been at that point convicted of murder, and so she was providing information to his attorney to try and help him. And she didn't appear at that PCR hearing, and so this offer of proof was made by Emily Blood, the attorney. And she said that Nicole Bailey told her that she got a phone call, and it turns out that it was Christopher Dunn trying to get a hold of her and talk to her. And they chatted she accepted the phone call, and she chatted about the birth of the baby and so on. When I questioned her about the timing of the reception of that phone call, she seemed somewhat unsure and offered that maybe it was after the Hunter program was over, because she had also watched Hunter that night. And that's about as pinned down as I could get her on the timing of that phone call. That's the extent, and the judge says, of the offer of proof, and she continues. So that's the extent, the length of the phone call. She estimated to be what she called a short phone call, and then she estimated it to be 5 to 10 minutes in length. And we heard that she told Ms. Blood everything that she testified to in court, but that's not true either. Because in 1993, at the time of the PCR hearing, this was what she remembered, that she had a short phone call with him at some point, couldn't really pin down the time, and it was a short phone call. And we know from the statement that Ms. Dunn gave to the police before Christopher Dunn had an opportunity to talk to his family and coordinate his alibi, Ms. Dunn said he was home around 11:30, and then he left and came back at 2 a.m. So it's very possible that Nicole Bailey did talk to Christopher Dunn at home that night, but that she is not correct and does not recall what time that was. We heard Ms. Bailey testify today that she doesn't have a memory of being on any medications. Then we talked to her about those medications. She indicated, well, I wasn't on any that would affect my memory. We saw that she was on a regular regimen of medication 24 hours after giving birth to a baby. It's fair that just like she didn't remember those medications, she wouldn't remember the specifics of this phone call. So now, let's talk about the eyewitness testimony that has been presented to this court. I'm going to back up. The allegations from the circuit attorney in their motion to vacate is that these recanting eyewitnesses lied and that they had a motive to lie. The evidence shows that these boys had absolutely no time to fabricate any sort of identification. And there's a lot of allegations about, throughout the record, about police coercion, about the police pressuring them, saying that Dunn was someone they wanted to get off the streets. He was causing a lot of problems for them. Talking about how the police were showing them pictures of their dead friends, telling them, you have to make this right. And there is absolutely no evidence of that other than those claims. You heard from the lead detective today, as well as the lead prosecutor on the case, that said they just followed the evidence and that these were two witnesses who were consistent and cooperative throughout. So let's look at those statements. So Michael Davis, we heard this today, Michael Davis first identifies Christopher Dunn as the shooter to Rico Rogers' brother. And we talked about this a little bit yesterday, but Rico Rogers was on the porch of Marlon Tolliver, which is on the same street he lives on. So, you know, we can assume that Michael Davis runs down the street just a few houses down and then lets Jerwai Rogers know Christopher Dunn shot your brother. And this is immediately after the crime happens. And then Michael Davis gives a statement to the police. We heard about that today. He said that the shooting happened, that he saw his friend fall to the ground, that he instinctively decided to fall next to him and play dead. He never said that his instinct was to run away and take cover. This 12-year-old boy's instinct was to play dead and to fall down. And that's what he did, and he could see as he was falling and looking that the shooter was Christopher Dunn. And then Michael Davis came and testified in front of a jury, and this is just one part of the transcript from that jury trial where he identifies Christopher Dunn as the shooter. But he tells the jury, and do you see the person in the courtroom today who fired those shots? Yes, sir. Who was that? Christopher. I'm sorry, Christopher. Okay, the defendant, Christopher Dunn? Yes, sir. And, excuse me, then we have DeMaurice Stepp. So DeMaurice Stepp identifies Christopher Dunn as the shooter immediately. Not only is that supported in the record, in the police reports, but that's also supported by testimony from Eugene Wilson, who also says that right away he was saying, and I think we looked at his testimony from his habeas hearing, it was Christopher Dunn, or Christopher Dunn shooting at us. So again, prior to the police ever arriving on scene, DeMaurice Stepp, running away from the shooting, meets up with his friends Marlon Tolliver and Eugene Wilson, who are in the 5500 block, walking west towards the Chinaman. And he tells them Christopher Dunn is shooting. Along with Eugene Wilson is this individual, Derry D. And he talks to the police and says the same thing. Right after the shots were fired, they meet up with DeMaurice Stepp, who is fleeing the bullets, and DeMaurice Stepp says that Christopher Dunn is shooting at them. And then we have DeMaurice Stepp's first statement to the police. So we heard today that initial officers arrive on scene, start securing the scene before homicide detectives can get there. And whenever they do, they make contact with DeMaurice Stepp and Michael Davis. And DeMaurice Stepp said that they observed Christopher Dunn as the individual who had done the shooting. Then DeMaurice Stepp is also interviewed by the detective. And you heard about that statement today, and he told the detective what he saw, told him that he was sitting on a porch with his friends, that he heard a gunshot, that he looked over, he saw Christopher Dunn firing a weapon, and then he looked away, heard a second shot, and ran. And that he ran towards the 5500 block of Labadie, where he then met up with his friends and told them what was going on. This portion of DeMaurice Stepp's statement was talked about a lot today, when he said, I looked at his face, but you know how you see somebody and you don't see him, you I thought my mind, was playing games, and I looked dead in his face. And Judge, we cannot assume or interpret what DeMaurice Stepp meant by that. We've heard a couple different interpretations of that. But the reality is that he said that he looked this individual dead in the face, and he identified him as Christopher Dunn. And then DeMaurice Stepp told the jury, and again, this is just a part of that transcript, where at trial, where he identifies him a couple of times, but when he's asked, all right, and as you three were there, what happened? He said, I looked around on the side of the gangway where the two gangways were, and I seen Mr. Christopher Dunn. Then he proceeds to talk about what happened and how Christopher Dunn was the shooter. It's important to note that prior to, or up until the jury trial, these two boys were incredibly consistent in their identification and in their recounting. I believe that there was some argument that their statements to police were inconsistent. But inconsistent is contrary to. I believe what we heard is that DeMaurice Stepp identified Christopher Dunn as wearing a white t-shirt and a blue baseball cap. And that Michael Davis identified Christopher Dunn as wearing a white t-shirt and sunglasses. I submit to this court that those are not inconsistent, though it's just two individuals focusing and seeing different details. The testimony was not that one individual placed him in a blue shirt or a black hat. An individual didn't say that he was wearing a different color hat. It was just different items of clothing, and that's reasonable. No two people experience anything the same, and that's just common sense. People focus on different details. So I submit to this court that their statements were not inconsistent. Were they different? Absolutely. But they're different people, and they're looking at different things and experiencing different things. So these two boys are extremely consistent and repetitive in their identifications through the jury trial, through the conviction of Christopher Dunn. The first time that any inconsistencies begin is after DeMaurice Stepp is convicted of murder, and he himself has been in the Department of Corrections for almost a decade. And in his recantation, this is where the inconsistency begins. In his recantation, in the affidavit that this court heard testimony about, it's in the information and evidence available to the court, that a inmate in prison helped him write this affidavit. And not only did he help him write the affidavit, but he identified another individual as being there who had also written an affidavit saying that this was his version of the events. So essentially, we have this recantation from DeMaurice Stepp where he says he sat on the front porch and 4 people started to shoot at us. And he also later in that affidavit says Tony Kelly was there too, but they didn't want to use his statement because it didn't go with the police statement. This is where the lies begin. And I submit to this court that those lies are influenced by DeMaurice Stepp being in the Department of Corrections and Christopher Dunn having access to him. We also heard testimony, I believe that this came out during what the experts relied on, the affidavits that the experts in this case relied on. We heard about an affidavit that was submitted, or that was signed and sworn to by an individual named Tony Kelly. Now, Tony Kelly doesn't come up anywhere else in the records, and the court will see that in all of the submitted evidence or admitted evidence and information available to the court. But Tony Kelly fills out an affidavit, and in his affidavit, he says there were 4 people. And that explains why DeMaurice Stepp puts 4 people as the shooter and also places Tony Kelly there, because this is the story, the cultivation of the story beginning. DeMaurice Stepp was interviewed in 2017, and even then, it's very different than what he put in that affidavit, because that story didn't work. That one didn't match up with the rest of the testimony and with the rest of the evidence that had already been presented in this case. And so that story was abandoned. And then in 2017, DeMaurice Stepp said that he saw Christopher Dunn there. And at this point, he said that there was another individual there with Christopher Dunn. And he doesn't know which one the shooter was. But unless Christopher Dunn has a clone walking around, he saw him. I want to talk a little bit about the evidence that was presented by the circuit attorney with Eugene Wilson. Eugene Wilson testified that he was walking up, approaching the porch of where this shooting occurred. Nobody else puts him there. Every other statement that is available to this court to consider is that Eugene Wilson was walking to the Chinaman restaurant, was walking towards it, and was not near the house at the time of the shooting. The 2018 testimony from DeMaurice Stepp in the habeas hearing, he says there's no way that Eugene Wilson could have seen what happened because he was not there. Eugene Wilson cannot say what Davis saw. He cannot say what Stepp saw. And he told this court that he was guessing or assuming. He also talked and has talked over time, the couple of times that he's provided statements about this case, about how it was dark, there were street lights, but no lights coming from the house or on the porch. And yesterday he showed this court where those street lights were in 1990. He marked them on the demonstrative exhibit used by the circuit attorney, and we had another look at them today with Dr. Franklin. Even if this court finds that he is being truthful about where he was located at the time of the shooting, which I submit to you is not credible in light of all the other evidence, his testimony is still consistent with the witnesses on the porch, DeMaurice Stepp and Michael Davis, being able to see the shooter. He said that he and the other boys had been outside all night and evening. Common sense is that their eyes have adjusted to the dark. He said that he was within talking distance of the boys on the porch. And he agreed with me that the boys on the porch would also have been within talking distance of the shooter. He testified here in court that it was light enough for him to see the faces on the boy of the porch. And he also said that the muzzle flash would have allowed him to see Dunn because he was light-skinned. What this tells us is that it was also light enough for the boys on the porch to see the face of the shooter. They were also within talking distance of the shooter, and there was enough light for someone within talking distance of someone else, according to Eugene Wilson, to see that individual's face. Also, there's already enough light to see their faces, but the muzzle flash of the gun would provide additional light, and he agreed with me that it would have provided additional light and enough light for people on the porch to see the shooter being in a white shirt, which DeMaurice Stepp and Michael Davis both reported the shooter to be into law enforcement. Eugene Wilson's testimony also gives interesting additional information to the way this shooting happened. Now, for the first time this week, the court heard evidence of some potential alternative motive. Now, the state never had to prove motive in this case, and the state has no burden here today. But it's convenient now that there's an alternative motive with zero corroboration of the incident for which they claim some sort of retaliation is being taken. Eugene Wilson testified that Christopher Dunn was not friends with DeMaurice Stepp or Michael Davis. Christopher Dunn had been friends with Marlon Tolliver and Eugene Wilson since they were young children, though. Wilson testified that he knows Christopher Dunn would never shoot at him or pig Marlon Tolliver. But he agreed that Dunn did not have the same level or type of loyalty to Stepp or Davis. So the evidence is that DeMaurice Stepp saw Christopher Dunn in the gangway before the shooting started. And Wilson agreed with me that all of the shooting was going towards the porch. He was not shot at and never felt any bullets fly by him. And the court heard from Mr. Roeder that the only ballistic damage at the scene was to a gutter on the porch and to the victim's head. And so I would submit to this court that Christopher Dunn was seen in the gangway as testified to by DeMaurice Stepp, and perhaps longer than Stepp saw him there, but hiding in wait and saw his close friends that he has that loyalty to leave. And once they were no longer on the porch, he shot at the two people that he doesn't have loyalty to and did not shoot at his longtime friends. Judge, although we don't have to prove motive, and the state never had to prove motive, there is a motive here, and that is the evidence that this court heard about the gang affiliation or the gang perpetration going on in the Wells Goodfellow neighborhood at that time. And I'm going to go through this pretty quickly, but the eyewitnesses told the police, or Demoris Stepp told the police, that the boys in the neighborhood started calling themselves Bloods, and that Christopher Dunn had started identifying as a Crip. We also have that sworn statement from Eugene Wilson where he happens to initial right next to the paragraph where it said Chris Dunn had recently been incarcerated, and whenever he was locked up, the neighborhood started turning blood, and he was affiliated with the Crips in jail. We know that Rico Rogers was wearing a red hat and red tennis shoes at the time he was shot at, and we know that Christopher Dunn was wearing a blue hat. Gang violence and gun violence don't make sense, and it doesn't have to make sense, but gang violence and gun violence are typically senseless crimes. And I submit to you that even though we don't know what the motive is, and it might not have been that, we don't have to know, but it certainly tracks. Your Honor, you heard testimony about those eyewitness identifications, and Dr. Franklin testified about how familiar face recognition can be automatic and rapid, how a familiar face can typically be recognized in a fraction of a second. And the record and evidence shows that the defendant, or that Christopher Dunn, was familiar to these boys, and the circumstances exist and are credible and are supportive of them having correct and accurate identifications. And a jury thought so too. The real question regarding motive is, did these boys have any motive to lie? And they didn't have time to. The first ID and every ID subsequent to it, up through the trial, came whenever this 14-year-old boy was under stress of a dangerous event, similar to an excited utterance, something that courts find declarants are more reliable when making those excited utterance under the circumstances and stress of those events. Something that Judge Omer said whenever he was testifying stood out to me. And he said, "You can't just rely on what's put down on paper. You have to talk to the witnesses. You have to get a feel for them. You can't just read the police report." He said, "I have to make my own determination." This court will never hear and hasn't heard from the two witnesses that have allegedly recanted their identifications. But some people have. Detective Stum interviewed them. Judge Omer heard them testify at grand jury. Judge Omer heard them testify at trial. He said that their testimony was strong and that they were cooperative throughout the way and throughout the life of the case, and a jury agreed. An innocent man's best defense is the truth, and you've just heard lies from Christopher Dunn. And he's never told you where he was that night. If the court has doubts as to the truthfulness or reliability of the evidence offered in this hearing, then I submit to you that that evidence is not clear. And if the court is not instantly persuaded that Christopher Dunn is actually innocent, then I submit to this court that it is not convincing. 34 years ago, Rico Rogers' murderer was convicted by a jury of 12 people in the city of St. Louis. That verdict was accurate, and that verdict should stand. Thank you.
Thank you, Ms. Eastup. Are you doing the rebuttal? Okay.
I will, Your Honor.
Okay. may proceed.
Thank you, Your Honor, and may it please the court and counsel. Judge, fantastic, incredible explanations for these two boys' lies, unsupported by any evidence whatsoever, does not matter. Their failure, the Attorney General's failure to even mention the controlling Supreme Court precedent here speaks louder than anything that they've said to you today. After all is said and done, Judge, at the end of the day, the bottom line is this simple fact. No credible evidence of guilt remains, and that fact alone ends the discussion. As it was in Amrine versus Roper, so it is in the case of Christopher Dunn. There is no physical evidence linking Christopher to the crime. Instead, he was convicted solely on the basis of recanted testimony. And whether they lied at trial or lied when they recanted and recanted again and again does not matter. The fact remains that this conviction is solely based on the testimony of proven liars unworthy of belief. And therefore, no credible evidence remains to support this conviction. The Supreme Court told us in Amrine versus Cooper at pages 548 and 549 specifically, held that under these rare circumstances, there is clear and convincing evidence of actual innocence. And as such, confidence in this conviction is so undermined that it cannot stand and must be set aside. Judge, these rare circumstances present the court with a rare opportunity. Based upon these facts, the absence of credible evidence before you, and the clearly stated law of the state of Missouri. The circuit attorney refiled this matter only after a thorough and independent investigation. Now we implore you, Judge, to do what Judge Hickel could not do 4 years ago. Grant our motion and finally set aside the conviction of Christopher Dunn. That's all.
Thank you, Mr. Shaw. Thank you, everybody. I know we've already entered an order, I think, that sets forth the post-trial briefing schedule, correct?
I don't know if it's been written down. I think it just was stated on the record. So we
Okay.
can write that down
Okay.
for you.
Yeah, if we haven't done that, we will do that. So you can do a memo that says case submitted, and whatever those dates you previously said are fine with me. I want to thank both sides for your zealous advocacy in this matter. And, I think our system is set up to be adversarial, and I'm not sure that was contemplated when this proceeding, or in these types of proceedings, but I do find it valuable that we have the Attorney General here cross-examining and adding to the evidence. Although it does make my job a little harder, I think. So I think that's all I have to say. I think I have plenty of work to do. You guys are all welcome back here anytime, but please don't come back very soon because I have a lot of stuff to do right now. So thanks, everybody. We'll be adjourned for today.